ಕೋರ್ಟ್ ಆಫೀಸರ್, ಸಿಟ್ಟಿಂಗ್ ಲೇಟ್ ಇದೆಯಾ ಇವತ್ತು?
ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಬರ್ತಾರೆ ಬರ್ತಾರೆ.
Sorry to keep you waiting because of some program. Yes.
The posting for memo, WP 511 of 2021, which was last heard on 25th January, with a 2 weeks period to be posted.
What is it about?
Pardon, sir?
What is it about?
It is about the registration of deed of declaration without authority of law.
Listed within 2 weeks.
Sir,
What is
last
it?
section of the people are suffering. I request you kindly consider, sir.
Within 10 days.
Yes.
I'm moving this memo, my lord. The
Yes,
petitioner is
one
elected-
after, yes.
My lord, this is a civil contempt petition, my lord, for disobedience. My lord, the order is dated 13/9/2020.
After 10 days, yes.
My lord, the petitioner.
Subject
is
to
a-
removal of office objections.
Yes, sir. The petitioner is a licensed mining holder, my lords. He is engaged in excavating iron ore, my lords. The director and the department have seized the iron ore, my lord, saying that illegal dumping has happened. And they have they have scheduled the auction on 16th, my lords. There is an urgency. Tomorrow the matter may be taken, my lord.
So auction is held.
Auction is there, my lords. Where they
When
have-
going to be held?
16th.
16th.
Yes, my lord.
So you're holding the quarry.
Hello?
You're holding the mine.
Yes, my lords, the iron ore which is excavated.
Now it
this
is,
belongs to me.
now it is cancelled.
No, my lords, it is not cancelled. My lords, they have seized the iron ores which is excavated by me, saying that it is illegally dumped.
Day after tomorrow.
Please, my lords.
My lordship, may I please make a request?
My lord, one matter for reporting settlement.
Settlement.
My lordship,
You're withdrawing.
Not withdrawing, my lord, we'll report settlement.
Compromise.
May I, Lordship?
Next week,
Monday, any day.
next Monday.
my lordship, may I please make a request? Serial number 61.
Serial number
61.
61.
We kindly humbly request the honorable court to adjourn it for next week, sir.
Memorandum of settlement.
My lord, fresh matter.
Yes, what-
Serial number 61, sir.
62, yes,
61.
61.
We are looking for adjournment for next week, my lord. Adjournment for next week,
Next week, after 10 days.
after 10.
Serial number
My
44.
lord,
Yes.
we are moving a memo for the company appeal, Your Honor. Appellant has already deposited the amount before the trial court. There is some extensions because the amount what we have given as a rent to the appellant, that is actually a personal loan amount. Now we are paying a huge interest, my
It
lord.
might not come here. How much?
Commercial.
It will not come here. Check up the roster. Yes.
My lord, in writ petition, my writ petition is allowed, but a condition has imposed to not use the code of
My,
Yes.
My lord, my writ petition is allowed. I challenged the order of the BBMP to stop using the premises for the Gordon purpose. So I challenged it, writ petition is allowed, but a condition is imposed to use the premises only for non-commercial purpose. It is a warehouse. I cannot use it for any other purpose.
By appeal.
Yes, my lord, my preferred an appeal.
Let it be after 2 weeks. No urgency.
Much,
After 2 weeks.
Fresh matter.
What fresh matter?
It's for the BBMP is publishing the elected MLA's posters in the public properties, my lord. It has been ordered by this honorable court as well.
Mr.
as-
Counsel, why do you mention once you remove the office objection, listed within 5 days?
Office objection, I have.
Then we'll get it listed within week. If you mention, we'll say week, 15 days. Normal rule is to be listed within 5 days. So if you mention you are at a discount, we don't mind mentioning. But this is what we are telling you. The matter might come earlier than we say upon your submitting memo. Yes, Mr.
My lord, one fresh matter. We have complied with all office objection in the month of Jan, my lord. It is not listed. There is to consider interim prayer, my lord. There is some serious urgency. The respondents are initiating contempt proceedings, my lord.
After 10 days.
Please.
My lord,
May
this
I,
is
Lord?
about the illegal construction. It was heard on 9th October 23. So I want at least next week if you can make it here
It is
again.
already, it was posted on 9th of October.
October, it was heard at that time, the previous Chief Justice. I want at least on 20th March.
Let it be after 2 weeks.
Yeah,
If,
thank you.
if the date is given, then we will not change the date.
No, we are asking for 20th March. After 2 weeks only, after 1 week, I'm asking.
No, Mr.
If you-
Party in person, if date is already given, then we will not change.
No, date has not been given.
20th March.
My lord, fresh matter. My writ petition seeking denotification of lands has been dismissed on a finding that I'm not in possession of the lands, my lord. What has happened is third parties who are claiming to be allottees of the certain sites formed on the land have now entered the property and they're making sites on their own with certain illegal forces, my lord. This they are already created several encumbrances on the land. If it may be listed, my lord, this week.
It can wait after 2 weeks.
My lord, they've already entered, they're already creating sites on the land, my lord. The entire nature of the property has been altered.
After a week.
My lord, may I request for a date this week?
A date, not this week, next week, 19th. Earliest is 19th, yes.
My lord, in the writ petition, my lord, the respondents are actually using excessive explosives to blast the stones, which is causing disturbance to the general public as well as to the localites who are staying
group.
nearby. And it is noteworthy to know, my lord, there is a school as well as temple within the radius of 500 meters. And hence I request my lord to have this matter for tomorrow. Your Honor.
So the authorities are undertaking blast.
They are operating query operation, my lord, and they are using excessive explosives to blast the stones.
So you are bringing PIL,
Yes, my lord. Kindly have this matter for tomorrow, my lord.
not next week, 20th.
This is advocate for complaint, my lord. Advocate for complaint. In this, the
Pardon?
order has been not complained. This is of the content matter. So it is
Contempt.
what-
After 2 weeks.
My lord.
Then it will be listed once you remove the office officer. That is what we are telling. Don't mention, we'll say 2 weeks. In the alternate, we will come within 5 days if you remove the office officer. Yes.
So serial number 44, your lordship.
44, yes.
44. Arguing counsel is, there is some inconvenience. Arguing counsel is unwell. So short date might be accommodated, your lordship.
So you want time?
Yes.
All.
My lord,
After
the date may be.
After 3 weeks.
Serial number 55, lord, there is some inconvenience
15,
today.
15.
55, lord.
55. Yes,
Sorry,
fine.
lord, serial number 41, I'm sorry.
40.
Serial number 41.
41.
Yes, ma'am. 41.
Yes.
41.
Please, ma'am.
22 appeal. 2 weeks.
Lord, it's a writ
May I
appeal
make one
matter.
submission on that? One contempt matter on that complainant has filed the complaint against that accused on that in this matter on that. What happened on that? I am the absolute owner of the land bearing survey numbers and some of that. And but the trial court has granted the injunction order on that. That was attained finality on that. And I filed the regular appeal before the appellate court on that. Appellate court has granted stay order on that. Stay has been granted on that. Now the accused person encroached my land and started construction work in the land on that. Already that basement was completed.
So what do you want?
So your lordship may kindly tomorrow all that extreme urgency in that. Tomorrow all that.
Next week.
Day after tomorrow all that. At least because what happened all that, if the construction is going on all that, it is very difficult to us all that. Day after tomorrow all that.
Next week. Yes.
Writ appeal matter, my lord. BMTC is trying to interfere with the possession by taking the advantage of wrong mentioning of the boundaries in the sketch annexed to the grant, my lord. And the learned single judge has passed an order to go before the court. But prior to that, honorable single judge has also passed that to go before the ADLR, and I preferred the this one, my lord. The order was not complied by the ADLR.
So for contempt.
Please, ma'am.
2
My
weeks.
lords,
After 2 weeks.
Serial number 43, Your Honor.
43.
Seeking time for preliminary hearing, Your Honor. 2 weeks time.
3 is writ up 816.
Yes, Your Honor.
So what do you want?
Seeking time for the further hearing, Your Honor. Seeking time for at least 2 weeks, Your Honor.
2 weeks. 2 weeks.
May I, lordship?
Serial number 15, my lord. Serial number 15, my lord. Will
15.
15.
Yes.
Will comply with the office objection. Will file the amended cost title. Will correct the amended cost title. Seeking time for that. Adjournment for that.
One time.
Yes.
May I, lordship?
Let it be called out. 15. At that time we'll consider.
Lordship's kind. There are two fresh matters, my lord. One is the appeal by the Customs Department, where the Honorable Single Judge has quashed the proceedings. And there was a seizure of the narcotic drug. And my lord, what to have been considered during the course of trial has been considered during the course of 226. The accused may abscond in view of the quashment of the proceedings. But your lordship may have it on next week, anytime, lord. Papers are in order.
Next week.
Both the matters. And
May I, lordship?
yes, I shall. I'm good.
May I, Lordship? May I, Lordship?
Yes.
This is Muralidharan, party in person appearing from Chennai, my lords. It's a public interest litigation which was not heard after 7/8/2023. I had posted a memo of posting, my lord.
Audible. Is audible not?
Your voice is not audible.
Your
Oh,
voice is
God.
not clear and audible.
Apologies, my lord. I'll try to come in tomorrow. Sorry, my lord.
You're mentioning some matter in the cause list or independently mentioning?
I had posted a memo of posting. Unfortunately, they wanted to place it in hard copy, my lords, in person in the court, and I had requesting for a exemption, my lord. I have filed it, e-filed the memo of posting. I just pleading for a exemption.
Who wants to post the matter? So after 2 weeks.
The e-filing is already done, my lords. The date requested is coming Monday.
Kindly see, regarding office number subjection 1, kindly see, I have already in the petition itself, I have explained why respondent 3 to 5 were arrived as party. Kindly see page 6, my lord. Page 6, above the page. Note, the accused number 3 to 5 have been arraigned as party to this contempt petition. Since the accused number 3 to 5 have joined the accused number 1 and 2 disobey the order of annexure interview passed by this honorable. This is the objection.
Say civil contempt.
Please.
And they are not parties to the order in which.
Writ petition, they are not.
So go before learn a single judge and make party.
No, then I will,
You delete.
delete.
Not only that.
I may be
please write
permitted.
down. No, not only that, this contempt is directed against the order dated.
Order dated annexure 5-1. Annexure D, page 5-1.
Which is the interim order in the pending.
Interim order was granted after. Please.
Which is the interim order in the pending writ petition, which does not crystallize the rights of the parties finally. It is also, it could be also noticed that the contempt is alleged against the parties who are not the parties impleaded in the parent proceedings of the petition.
One submission.
On both the aforesaid counts, this court does not enter in the contempt petition, reserving liberty for the applicant to approach learn a single judge.
One submission.
To work out the rights in relation to the order brought under contempt, and also to join, also to make prayer to join the parties against whom the non-compliance is alleged.
One submission.
Disposed of accordingly.
In similar interim order, this court has already issued a notice to the accused. But 3 and 5 I will delete. I may be permitted to. But
whatever you want to do before learn a single judge.
So number 2. Since this interim order, after hearing the parties as it has been granted.
This is not the appeal where you can do everything, all these things.
No, my lord. Once
so go there and do it, whatever you want to do.
We have taken the view against interim orders. Please. We are not entertaining contempt. You can go take up that grievance.
With liberty to move the single judge.
Yes, it
please.
This is
Timing question is a reserve forest. They are timing right over.
So Srinivas B.
Lord, I appear for petitioner appellant in this case. I pray for 2 weeks accommodation. Lord, lot of.
This court does not express any opinion on the merits of the case of the other side, and the contentions before learn a single judge are kept open for the contesting parties. Yes.
Lord, I pray for a week's accommodation, Lord, to comply with the office objection. Translation and typing I have not yet received, Lord. I have given the documents. All documents are in Kannada. I have given it for translation. 2 weeks accommodation.
2 weeks. 2 weeks time is granted to remove the office objections, failing which the writ appeal shall stand dismissed without reference to or order of the court.
Number 3.
My lords, I pray for my lords, I pray for 2 days time. My lords.
Why?
To file a typed copy of page number 46. Course of the day.
Which annexure?
It's annexure F, my lords, page number 46. I have to.
Annexure F.
L.
Annexure F, my lords, page.
F. Page number?
I have to submit a typed copy of page number 46, my lords.
46. All items. Prayer is only to consider the representation for environment clearance certificate.
Yes, my lords.
We can direct the authorities.
We'll direct them to consider your prayer.
That's it. Heard learned advocate Miss so and so, so and so. For the petitioner, what is prayed in this petition filed under Article 226 of the Constitution is to direct the fifth respondent, dash the State Environment Impact Assessment Authority, into bracket SEIAA, Department of Ecology, Environmental Forest, to consider the representation dated 22/12/23 of the petitioner. A copy of the representation is produced along with the record of the petition at an X-ray. It is further prayed to direct the said respondent to consider the application of petitioner for grant of environment clearance. Full stop. It is the very request advanced in the aforesaid representation dated 22/12/23. The aforesaid prayers are made in the background of the facts inter alia that the application is made, that an application is made by the petitioner before the competent authority for grant of notification for extraction of ordinary building stone in the area of 10 acres and 39 guntas in survey numbers 122/1, 122/2, 122/3, and 122/4 at Chika Savanur village, Chirati Taluk, Gadak district. It is stated by the petitioner that one of the requirement is to obtain the environment clearance certificate in addition to compliance of other certifications to be obtained from the competent authorities in relation to the grant of permission to extract the mineral. Full stop. Since the prayer paragraph before this court is only to consider the only to require the respondent authority to consider the representation petitioner, comma, the said prayer to the said extent could be granted. The competent authority of respondent, as respondent, the fifth respondent, as the fifth respondent, is directed to consider the representation dated 22/12/23 of the petitioner for grant of environment clearance certificate, which shall be done after taking account all the relevant facts and in accordance with the merits. Full stop. The decision on the representation may be taken within 8 weeks from the date of receipt of the order. It is observed paragraph that this court does not express any opinion on the request of the petitioner and about the grantability of the environment clearance certificate. The petition is accordingly disposed of.
Notice may be asked. Notice because for R5 D Nagaraj appears.
Your appeal?
I appear for R1 to R4.
D Nagaraj.
D Nagaraj appears for R5.
So heard learned advocate so and so, learned government advocate Mr. Mahendra appears for R1 to R4, whereas learned advocate Nagaraj, who normally appears for this 1.5, is directed to accept the notice. Paragraph. With consent of the learned advocacy parties, the petition was taken for final disposal today. Then further, whatever dictated. Yes.
Number 4, Mr. Karnataka P.
4, my lord, I pay for the petitioner. Lord, pay for a week's time to comply the office objection. Office objection is that prescribed affidavit should be filed in a prescribed form. That has to be done.
What is the objection?
Ob-
Affidavit. So office objections may be complied with, shall be complied with within 2 weeks, in which the petition shall stand dismissed automatically without reference to or order of the court.
Number 5, Mr. Muralidhar HM.
Hearing for petition. A week's time may be granted, my lord. Only Kannada translation part is left, my lord.
Serial number 5.
Yes, 5 and 6, both.
But the only one office objection.
Yes, translation. copies.
Translation. All right. 2 weeks.
Yes, ma'am.
2 weeks time is granted to remove the officer. Failing which same.
6. 6 also. Same.
Same.
Number 7. Mr. Somshekar KM. Mr. Somshekar KM.
Yes. You want time to remove the office officer?
Yes, my
2
lord.
weeks.
100
2 weeks.
2 weeks.
Same order. Yes.
So number 8, Mr. D. Nagaraj.
Complaint partly, Your Honor. Translate copy.
13%. Your 13%.
No.
Where is your band?
Oh, sorry.
So come with the band. Yes, next. Keep back. Yes.
So number 9, Mr. Srinivas Rao CN.
2 week prayer time. Prayer time.
2 weeks. That same group. 2 weeks. Same orders.
So number 10.
Kindly grant 2 weeks time, my lord.
2 weeks. Same order.
Please.
So number 11.
2 weeks.
Shekrappa.
2 weeks time I have to complete it.
But here you got remedy of appeal.
2 weeks time I have to complete that.
All right. 2 weeks.
For order, seal number 12, Mr. Praveen Kumar N.
My lord, in this I seek my lord's pardon. My lord, the order dated 10/1/2020 had not been complied with. My lord, on 4th of March, I had undertaken that I would comply within 10 days. My lord, I pray for some more time, my lord.
That storm water coverage,
My lord, deaths in the open drains.
covering the drains.
My lord, I apologize. My lord, finally, my lord, 4 weeks time may be granted because
So you are supposed to comply the order dated 10/1/20.
2020, my lord, and even 18/3/2020, if my lord could see. Paragraph 2.
So you are supposed to issue specific direction.
Yes,
Do it.
my lord, 4 weeks, my lord. Very well, 3 weeks. My lord, since the code of conduct might come in, I may not be able to.
Put up in the second week of April.
Second week of
April
obligement,
to be listed.
obligement.
The time, both hours. 18 to 20. 2 hours. 18 to 20.
The other complaints by the BBMP,
Yes, my lord.
18 to 2020.
Yes.
No one for BBMP.
That's for number 3 and 4, BBMP.
BBMP. This
Already
order 18 to 2020, you are not complied with.
Affidavit, my lord.
Huh?
Already complaint affidavit already filed it.
You have filed the compliance affidavit.
Yeah.
6 to 18.
To 2020 order. You have to.
When have you filed it?
earlier before the order, my lord. 24/2019.
No,
Sorry, my
Not
lord.
complied. That's not complied. You can't comply before the order is made.
Learned additional government leader, Ms. Nilofer.
Panel council. for the- AGA.
Nilofer. Akbar. Praised for further time to comply with the directions contained in the order dated 10/1/2020. At the same time, learned advocate Mr.
Panel councillor.
Bangalore Development Authority,
BBMP.
Mr. K.N. Puttagowda, my lord.
BBMP.
Yes.
For BBMP, also 6 time, since the directions received in order dated 18/2/2020 against BBMP are yet to be complied with. Both the council ensures that before the next date, the directions will be complied. And the necessary affidavit in that regard shall be placed on record. So when do you want?
My lord.
We'll grant sufficient time, but then no further.
Yes, my lord. I'll see that it is complied.
18th April?
Very well.
18th April.
Obliged, my lord. Oh, compliant.
My lordship, I'm for the respondent number 6 in this matter, my lordship. The office vacancies are, inquiry report has to be served other side, my lordship. I have served all the councils, my lordship. Previous order is also there, my lordship. In 23/2 of 2024, office notes to be deleted.
So you are served with the copy?
Yes, my lordship.
Let him, he is not here.
I served also AG also, my lordship. Ah, yes.
So what shall we do? Keep back or some other day?
Office objection may be delete, my lordship, because I have served copies to other side also. Inquiry report.
Office offices are complied with to be listed after 2 weeks.
Serial number.
Number 14, Naveed Ahmad.
Your lordship, week's time may be granted, your lordship.
In which matter?
In serial number 14, your lordship. Please, your lordship. I have already, I have to file the pro forma affidavit.
Petitioner. Yes, state you are here in this matter.
I appear for respondent number 1 and 4, my lord.
1 and 4.
Yes.
So who is for number 2? Who has filed the objections?
I have to file the pro forma affidavit.
Kalimullah Sharif.
So Commissioner, City Municipal Council, Raichur, you are appearing?
No, my lord, I appear for respondents 1 and 4.
1 and 4. Who is 1 and 4?
Government and Deputy Commissioner, your lordship.
One each state. Who is Deputy Commissioner?
Lord, Mr. N. Shiva Shankar and Mr. Kalimullah Sharif.
They have filed the affidavit on the presentations of the Who appears? Yes, Mr. Ahmed.
Naveed.
The affidavit is filed by the Commissioner of City Municipal Council, Raichur, which should satisfy you.
I have not got the copy.
Dated 27/9/21.
I have not received the copy, your lordship. I'll just get the instructions, your lordship. A week's time may be granted, Your Lordship.
Not it should be go. All right, next week.
Much
In
obliged.
the meantime, you find out what is your stand.
My lord, it is the city municipal council who has to widen the road. Very well, I'll get the info.
All buildings are,
Encroachments.
encroachment is removed. That is what the affidavit indicates. Next
Please.
week, keep it on 20th. So this will be disposed upon that next day.
Much obliged, Your Lordship.
For the, yes, ma'am.
Reply is filed, counter is filed.
No, counter is not filed.
Who will appear? This is regarding some lake.
Yes, encroachment of a
Lord,
lake.
I'll have to file the counter, my lord, with regard to the encroachments.
A lot of
Encroachment over the lake or some, what
Yes.
is the
A
grievance?
lake.
Encroachment,
Yes, encroachment of lake.
the lake,
Yes.
by putting up what? They are doing what? With
They are building roads on it and they're building their settlements on it. And the government is not taking action. We have given a representation. The representation can be seen in annexure N. There's also an order of the Tehsildar in annexure M, but still there is no action on ground. It's only paperwork going on by the government. Page number 68 may be seen, my lord.
you should file a counter.
Yes, ma'am.
Appears to be fair rate important issue. Learned additional government advocate. Takes time to file the objections. Which may be filed within 2 weeks.
3 weeks. ma'am.
3 weeks. 3 weeks. Put up on 5th of on 4th of April.
Obliged.
16.
Please.
Prakash,
My
Ramesh.
apologies, my lord. I am for the respondent number 2 and 3, my lord. They have filed an amendment application, my lord. I need to file the objections, my lord. In the last date, I had taken the application copy, my lord. I have sent the necessary objection to the authorities, my lord. I will file it within 2 days, my lord. Kindly have it next week, my lord.
You are for whom?
Respondent number 2 and 3, my lord. NHI, my lord.
National Highway Authorities, please.
It will go to April, 8th April.
Obliged, my lord.
Number 17. Narendra Kumar, party in person.
Lord, this honorable court had given an order to get claims verified for around 1 lakh depositors of 20 Ponzi companies, my lord. 2.5 years, they're yet to comply with that order, my lord.
Which order?
It was ordered dated 29th July 21. In WP 31624, my lord. Number 17.2.
Seventeen 11/22.
29th.
29/11.
29 July 21.
21.
Para 5, my lord, para 5.
What have you done? Huh?
The accused my lords who have been arraigned before this honorable court in the instant contempt were not my lords parties to the writ petition. Lords, dehouse that. In fact, my lord, the office has raised the objection so as to how the accused could have been made parties herein when they are not parties to the original petition.
Which is that order complained of? Violation is complained of, no?
Lords,
Which is that order? At what page?
Lords, para 5, my lords. The party in person refers to para 5, my lords.
Order.
29
My
July
lord, the
21.
competent authorities of respondent number 11 to 24, my
Report is already filed in the court.
Please file, please. Lord, if my lords permit me, my lord. In fact, in the PIL, lord, from where the contempt petitions, my lord, stem, the petitioner, my lord, before this honorable court saying that he's got absolutely no personal interest in the PIL and he's filed an affidavit. My lords, I have produced, my lords, the transcript of the address, if I can say so. Lords, the petitioner, if I can say so, sir, the petitioner, my lords, regularly issues YouTube clippings, by virtue of which, my lord, he not only comments about the court proceedings, but also, my lord, solicits persons to come to him to file applications on a payment of a fee.
Achha, have you got the order dated 13/12/22 passed by the court in these proceedings? Where it is recorded that the action taken report has already been sent to petition number 1 through email.
It's been filed, my lord. Action taken report has been filed.
So it is the same report which is contemplated in paragraph 5 of the order.
Oh, please.
Then
In
what
fact,
remains?
my lord, they have been, this is 5-year-old PIL, my lord, have been appearing in every hearing.
We are
My
on-
lord,
Today we are not dealing with
My
PIL.
lord.
We are dealing with your contempt application.
PIL is listed,
My lord, they have 2.5 years.
Confine your submission to the contempt.
They have not complied with the orders of this honorable court for 2.5 years, my lord.
You are referring to paragraph 5 of the order.
Yes, my lord.
Please read it.
My lord, we direct the competent authorities to process the claims within a period of 3 months from today in the cases where the claims under subsection 2 of section 7 of the said Act of 2004 has been received. In those cases where the claims have not been invited under subsection 2 of section 4, but the exercise of filling a report under subsection 1 of section 4 has been not complied with, the same shall be complied with within a period of 6 weeks from today. In those cases where claims have not been invited under section 2 of section 7, immediate steps shall be taken to do so. We make it clear that in those cases where the claims have been received, the verification has to be done expeditiously so that after making adjudication, the special court can pass an order, if any, for payment of the requisite amounts to the investors.
So the state government has filed the compliance report.
I appear for the authority to whom there is a direction, my lord, the Karnataka Protection of Interest of Depositors Authority, my lord. And the same proceeding, similar prayer, my lords, is also before the Honorable Special Court, my lord, the designated special court. In fact, my lord, we have been filing monthly reports before the Honorable Court. Lord, we have done all that was possible. But dehorse the fact that I was not, my lords, a party to the original petition, but I'll not stand on technicalities. I have placed it before the Honorable Court. But the intention of the petitioner as
Compliance, where is the compliance?
The report haki this,
Mandate in 5.
But we have filed, my lord, the
1.5
reports, my lord.
years, my lord, they have not submitted.
But we have filed, my lords, the one action taken report, my lord. I will file another action taken report as, my lords, the development from that report till date. Lords, I'll place it on record, my lords. I'll place it before the Honorable Court, my lords.
My lord, the direction was for the competent authorities who are competent authorities of respondent number 11 to 24, my lord. So they have to submit compliance report. They have not submitted for last 1.5 years. 2.5 years, they have not. My lord, 1 lakh depositors are waiting for 700 crores, my lord. Special court has been giving orders to sell the properties. They have not sold the properties, my lord. They have 5.5 crores cash, my lord. They're not distributing that also, my lord, for respondent number 12. And my lord, I have submitted one memo saying that they're not even attending courts, my lord.
the designated.
Please, my lord, as the statutory compliance, my lord, and even as per the directions of the Honorable Special Court, my lord,
To file summary of those reports
Uh,
here also.
please, please, please,
And
my lord.
satisfy us that the directions are complied with.
Please, my lord. Please, I shall, my lord. I shall, my lords.
Do it.
Please, my lord. Please, my lord.
I have one more submission, my lord. My lord, last 2 years, they have not been appearing in special courts,
Rest
special
you pursue in your main public interest petition.
compliance, my lord.
So this much we can direct. not-
Verification of all the claims, my lord. 5 years they have submitted claims, my lord. 5
Learned-
years they have not even
learned
verified.
party, please take. Learned party in person, complaints of, not complaints of the disregard. Is the grievance of the party in person is about the non-compliance of the directions in paragraph 5 of interim order dated 29/7/22, passed in writ petition number 3162/4 of 19. Full stop.
21, my lord.
The directions are with regard to filing of with regard to processing the claims of the depositors under section 7(2) of the protection of the Karnataka Protection of Interest of Depositors in Financial Establishments Act 2004. Full stop. While order dated 13/2/22 passed by the court in this proceeding reflects that the copy of the action taken report has been sent to petition number 1 to email, comma, learned senior counsel Mr. So and so appearing to the accused number.
Because compared to 40, A1 to A3, my lords, in CC 594, my lord.
We are for which party?
But accused number 1 to 3, please, my lord. 1 to 3, my lord.
1 to 3 submits that he will be filing the press report.
Please.
Covering the entire period.
Please, my lord.
Till date.
Please, my lord.
In compliance of the observations made in paragraph 5 of the order.
But behows the fact that I'm not a party to the petition. Please, my lord.
My lord.
Not he may be directed to appear for the competent authorities in the connected writ petitions, my lord, so that we can give it
I
a
will take
quietus.
notice.
Yes, ma'am.
You appear for the.
Please, all competent authorities, I'll take notice, my lord.
Such report shall be filed within 3 weeks.
Please, my lord.
Within 3 weeks.
My lord.
Full stop. Learned advocate Mr. So and so also state that he will be appearing in the connected.
Writ petitions for the competent authorities.
In the main writ petition. Main writ petition.
The main.
Yes, my lord.
Main writ
For the
petition.
competent authority.
Yes, my lord.
So the party in persons is directed to implead the authorities.
Competent authorities.
That authority is already there.
They're
some of
already
the
there,
matter-
ma'am.
Then
Please.
you appear.
Please.
They're already there, ma'am.
But they're also in the main proceeding.
But
For the authorities.
Please, my lord. 31624 of 19 is the PL which is listed today, my lords. WP 31624 of 2019, my lords, is listed, my lords, along with these matters.
17.2, my lord.
17.2. My lords would kindly take them. I have filed, my lords, the transcripts of, my lords, the YouTube addresses that are being released, the bulletins, if I can say so, from by the petitioner. But the entire modus operandi is, my lord, to invite, to solicit persons who are depositors to come to him. And not he's on record to say that he has a couple of very senior, expensive lawyers whom he has to give the papers and get the papers filed. Because I'll only to bring, my lords, to the notice of your lordships, the intention of the petitioner to file the instant PIL. It is not, my lords, the PIL in the sense of public interest litigation. It is much more than that, my lords.
To argue in the main matter.
If you comply with these things,
My lord.
where the PIL would have come
I
here.
board on, my lord.
Lakhs of people have lost their
My lord,
money.
I board on, my lord.
And you will take your own
My
sweet
lord,
time
my lord, may I
to process the application.
may I submit, my lord.
You file now, Honorable Chief Justice. has
Please,
said,
no, I
file
board
the
on.
comprehensive report.
I board on, my lord.
With full particulars.
I board on,
My lord,
my lord.
my lord.
I shall, please.
My lord, my lord.
Shall we keep 15th April?
Please, I board on, my lord. Because 9455.
My lord,
lords,
just one submission, my lord. My lord, they have been accusing only last 1 year after this contempt petition was filed. Before that, there were no accusations, my lord. They have submitted a fabricated evidence, my lord. My lord, sir. My lord, the submission of these transcripts are fabricated, my lord. I have submitted,
We are not taking all that.
fair, sorry, my
Some
lord.
order, don't waste time.
My apologies, my apologies.
My lord's permission, one repeats 9455, it's become infructuous, my lord. It's the list, my lords. WP 9455 of 2020, my lord.
17.4.
Please, my lord, please, my lord, 9455.
Is it true? It has become
Alright.
infructuous.
Plus, there's some other person, my lord. It's a connected, it's clubbed with this matter, my lords.
Why it has become infructuous?
My lords, during the tenure of the lease deed, my lords, the petitioner approached this honorable court that during the lifetime of the lease deed, I should not, my lords, be dispossessed from the property in question. Now, my lords, they've handed over the property in question to us, my lord.
So it needs to be auctioned by the court now.
Yes.
Please, Lord, subject to the orders of the division bench, subject to the orders of the honorable division bench where the MFA is pending, my lord.
On that they will dispose. That they will dispose.
I vote on it.
Give the word.
My lord, 17.1, my lord, there is one more contempt against the same people, my lord. They were supposed to have developed and they have not given any reply to the notices sent, my lord. Last time also, this time also.
All together on that.
I vote.
Number 18. Sarvana, yes?
Lords, appearing for the appellant in this matter.
Hearing for the statement.
Lords, disqualification under the Karnataka Local Authorities Prohibition of Defection Act. As per the deputy commissioners challenged before the Lords, the learned single judge, and the learned single judges confirmed the orders passed by the deputy commissioner. Lords, the factual matrix lies in a very narrow compass. The petitioners were elected as the municipal councillors of Arsikere Town Municipal Council. Lords, a representation was given saying that separate seating arrangement has to be made on 22/6/2021. Lords, then on 23/6/2021, the deputy commissioner directs the council to verify the signatures of the representation which was given on 22/6/2021. Lords, on 23/6/2021, the Taluka president, Lords, communicates to the deputy commissioner as also the chief executive council.
We'll take up on some other date.
Any short date, Lords, because the
Not today.
very well, Lords. The only problem is that these are the constituencies for which there are no elected councillors as of today, Lords. But
Calendar of events.
By election.
Yes, by election. But after the calendar of events are issued, my lords, that has been stayed by this honorable court. Of course, my lords, I leave it. Our hands are tied because the calendar of events are stayed.
no inquiry was conducted, Lords.
So this election to which council? Municipal council.
Yes, my
Yes.
lords. After the disqualification, my lord, the order of the
I-
learned single judge was on 21/7/2022, dismissing their writ petitions. We issued the calendar of events on 3rd of October 22.
So provisions of part 9A of the constitution.
Actually, that's what, because once calendar of events are issued, there could not have, but this honorable
But
court
Lords,
has-
may have this matter because this is an order passed in the
Where
instant
is the
writ
calendar
petition.
of
my
election?
lords, they have mentioned it in their own thing, my lords. It was issued on 3/10, published on
You are
6/10.
Which for election?
My lords, I represent the election commission. It was issued and published. Last time we had furnished that copy, my lords. Unfortunately.
This is
today
an
that
interim
is-
order which is operating since 6/10/2022,
In
Lords.
fact, that records that the deputy commissioner had to start the process from 6th. The honorable court has said he should not start the process.
It is stayed.
Yes, my Lords. It is stayed in this,
That
in
is-
this very matter.
In fact, my lords, the division bench is already held in identical matters.
Lords, once and for all, the matter could be disposed of. My Lords, now, number one, inquiry was never conducted by the deputy commissioner.
In
The
fact,
present
my-
president of the political party says, at the time when the proceedings were initiated, resignation itself was not received by them. At any rate, the resignation was never accepted as on the date when the proceedings were initiated.
Was the
That is the
election-
stand taken by
Lords,
the,
Close the election program. Where is
lords,
that?
it was published and we had
Not-
furnished. No, it is already said. In fact, the learned single judge's order is that. I mean, sorry, the division bench order staying. I can produce it, my lords. It was produced on the last occasion.
If your lordship sees, that's the interim order also says so. Please see the interim order dated 6/10/2022, my lords.
Notification dated 3/10/22.
3/10/2022. I can produce it by afternoon, my lords. It was given, handed over. What happens is we announce the calendar. The process starts from under 243 ZG. Once my calendar comes in, my lords,
Article 240
ZG, my lords. This is
ZG.
municipality, ZG applies.
ZG will apply.
In fact, the division bench, my lords, has considered that aspect because one of the grounds taken was election commission announces the schedule. That is not the calendar. That was negatived by the division bench in that judgment and said, once I announce, that starts the process. Now my hands are tied and because these disqualifying councillors, my lords, they try for a settlement amongst themselves. But my hands are now tied because of this.
Lords, if ultimately, my lords, if your lords were to allow this writ
Not
appeal,
oppose the
that
grant
entire
of-
process
Lords,
becomes redundant.
You did not oppose the grant of stay by the division.
We ex parte, my lords, we have not issued notice.
Then you did not file IA.
No, because my lords, the number of times this matter had come up, we had always said placed, but they would say it'll be heard, and that's all.
It is in 22, it is stayed.
My lords, I understand. The understanding was it will be taken up someday. My lords, what happens is the contesting parties will decide on a date.
So this program is for by-election or entire body?
No, only by election.
How
For the
many-
seats
how many
vacant, my lords,
How many seats?
the petitioner, this is, my lords, about seven seats.
7 seats, my lord. 7 councillors who have been disqualified.
7 councillors.
Lords, is my
And
fixed
now
date,
today
my
we
lords.
are in a-
Even Monday or on Thursday, next Thursday, my lords, any date, my lords, I am before your lordships. As a matter of fact, we have been requesting, my lords, but this honorable court had deferred the matter for hearing for some reason. But every date, my lords, we are prepared to argue the matter.
Already succeeded.
My lords, the question of succeeding doesn't arise because the scenario is that I am not a councillor and the elections has not taken place. It's a Trishanku Swarga.
In a way, you have succeeded. They will to have, even if you lose, they will have to issue a press program.
That of course, my lords, that they will have to know. Lords may have this matter.
When shall we take up next? 20th, 21st?
My lords, I am.
22nd, may I request, my lords, 20th and 21st. 22nd.
Only 22nd.
Lords, it's grateful.
These complaints.
Number 19, Ajay Kumar M.
Please.
I responded. Yes.
The appellant in the matter.
We represent the proposed respondents, my lord, 3 to 5. We have filed an application for including us as necessary parties in this writ appeal. For the reason, my lord, these including applicants are the purchasers from the original BD allottees. My lord, all these facts have been suppressed before the learned single judge, and they could be able to see that order is passed. Quashing the 30 guntas of, quashing the notification with regard to 30 guntas of the land. This was acquired.
You bought the property when the petition was pending or earlier to that?
Earlier to it,
Much earlier to that.
I am the owner of, I am the owner of 1 acre 30 guntas land was acquired. And I challenge the acquisition proceeding, saying that 1 acre I have already voluntarily handed over for the purpose of formation of the road. Remaining 30 guntas is in my possession. PDA came before the court and said that this land is only reserved for commercial activities. No layout plan is there. My learned friend said, no, this is the very same site is allotted, but there is nothing to show that it pertains to my property only. There is, unless, in fact, the BDA itself has filed an objection saying that this is reserved for commercial purpose. I just pass it on the plan itself, original plan itself shows this land has been acquired and formed the layout in the year 2000.
You're for Bangalore Development Authority.
I appeal.
Yes.
I am the appellant in the matter.
The purchase.
Plan, original plan, I should produce it, wherein it shows this land is also already formed the layout and
Sale deeds have been executed in the year 2014, my lord.
Acquisition set aside on what ground?
Pardon, my lord.
Acquisition is set aside on what ground?
On the ground that possession was.
Possession is not.
Possession was?
The ground possession is
Not
not taken. That is the ground which has been taken.
Possession
That's
is
what
not
the
taken.
trial court notes, my lords,
But
is
is
that.
Action was not taken.
That's please, Millards, the trial court, Millards, the learned single judge doubts the mahazars which have been placed on record. Millards, the learned single judge notes, Millards, that there are supposedly 2 mahazars under which the possession has been taken. And if I may, Millards, para 8 of the judgment, Millards, at page 26. The learned single judge notes that there is supposed a mahazar of the date 30th of October 2003.
Lord, in that.
And that has created a doubt in the mind of the learned single judge. Not correct.
Your application is
Yes, my lord.
IA number?
IA number 345, my lord.
Please.
345.
Yes, my lord.
3, 4 and 5.
Yes, my lord. They are the including applicant, they are the purchasers.
You bought the property prior to initiation of writ proceedings,
Before the
before that,
2014, it's.
from the allottees of the,
Yes, my lord.
But the issue is, my lord, whether it comes in my property or not is not clear. Kindly see page 57 of the.
that's true. But those who buy the property from the original allottees,
Correct, but does it?
Apex Code says they are necessary
TDA
parties.
itself has filed an endorsement before the single judge, saying that this remaining 30 kuntas I have reserved it for commercial purpose. They do not say it is allotted before the single.
They
judge.
have to be heard in the matter,
No, but.
because
no
they are
material
holding
is
registered
produced.
sale deeds.
Yes, no, but sale deed doesn't indicate a site number. It does not relate to this survey number.
Indicate site numbers as well. The original plan is
In
also there, my
fact,
lord.
we made an application seeking for the layout plan, but the authorities say that the plan itself is not there.
The earlier proceedings, the BD itself has filed an objection stating that all these sites have been found and sold. The BD itself has executed registered sale deeds, my lord. For all these sites.
The allotment letters are all placed on record by the implementing
Where
applicant.
is IA?
IA number, my lord, IA number 5, my lord. IA number 5, page number 73. Annexure R, objections of BDA. In earlier proceedings, 58689 of 2014. Srimati Veena. Page number 73, madam. Annexure R.
Possibly not there.
Annexure R 12. Annexure R 12, madam. 73.
Reply 4, 5 and 6. 4, 5 and 6.
Yes, madam. That's page number 73, madam. We have filed along with the application, along with additional documents under order 41 rule 27.
May I show one document? Didn't get till,
Your stand is that you have developed the land, allotted
We
the
have
sites.
in fact, Millards, in the previous round of litigation, Millards, which is being referred to by learned friend, Millards, page 74 at para number 2,
Clearly stated.
stand was cleared. Because the entire issue stemmed from, Millards, the issue whether the representation given was considered or not. Millards, the award itself, Millards.
So three different purchasers.
Yes, madam. There are more than purchasers.
But
Only
they
here
are
purchasers
three. Have to be allotted by
So
TDA.
we'll allow that.
Yes.
No, but I would say, Lord, kindly see page 57 of the BDA. BDA does not say we have allotted at any point of time.
That is.
Now
that is
the registered
subject-
sale deed
No,
is
but BDA should say, my lord, that whether it comes out of this property or not. BDA does not say that it is form part of this. Page 57, they say it otherwise. Kindly see page 57, my lord.
Mr. Once they say that they purchased the property under equity.
Or your lordship can consider
They
this
become
while.
interested party, at least proper party,
proper parties.
proper party, if not necessary party.
Lord, what I would request is, whether he is interested or not, your lordship may consider while hearing the matter itself.
No,
Let this
even-
application remain, because
Mr. Harnaldi, even otherwise, the cost title gets little elongated. And he will argue, we will also argue, whatever happens, happens.
All three, 4 and 5. you allowed.
Yes.
So the main matter will be posted when? After 4 weeks? After 4.
Please. Yes. Right. Now, the interim order may kindly be extended. Lord, there is an interim order.
no, he is not concerned with
Lord,
interim order.
we are-
Appellant,
we
you are
are
not
concerned.
appearing for the appellant.
We are also concerned.
No, no,
Outline
no.
is concerned. Lord, the interim order may kindly be extended, because there is a direction to
Please.
the R1, so not to alienate this land. He has already alienated a portion of the land.
We are not
Therefore-
alienating.
Therefore, on the last occasion, interim order was passed by this board. That we need. to
Well,
be
so
extended.
far as alienating is concerned, we will not alienate.
Accused, I filed a compliance affidavit dated 3rd February. We were directed to consider their representation to extend the OTS. We had considered their representation and rejected it. During the pendency of the contempt petition, they submitted another OTS proposal. And now the bank has sanctioned the OTS. May I just place that on record?
It has become infectious now.
Please, Milas.
The council for the respective.
That's one indulgence, my lords.
Jointly-
Once we comply with this OTS proposal, let them return the title documents, my lords. That's the difficulty, my lords.
Not our scope. It's not our scope.
Understand, my lords. Yes.
When the present contempt proceedings come up for consideration from a learned advocate for the accused, Mr. Vikram files memo dated 13/3/24, in which it is stated inter alia as under by letter dated 13/2/24 issued by the complainant, number 1, to accused number 3. A fresh OTS proposal has been both submitted to the Canara Bank. 2, by letter dated 11/3/24, the Canara Bank sanctioned the OTS in relation to the loan accounts of the complainants. Full stop. In view of the aforesaid memo, the directions which are brought under contempt could be said to have been complied with. And nothing survives in the proceedings to be adjudicated further.
I'm grateful.
Accordingly disposed of.
Just one small indulgence. Accused number 3 has been named as Vijay Kumar. His name is actually Vijayadev Asundi. I have filed a memo to that effect.
Now it has become infectious, even otherwise.
Great.
21, Kivina TN.
Lord, the petitioner's service has been, my lord, regularized in the year 2017, my lord, with all consequential benefits. My lord, right from 1997, kindly look at the order of regularization, my lord, page number 17. Relevant portion is, my lord, page number 19. Lord, with effect from, my lord, 1997, they have been regularized during 2017. Lord, our retirement benefits, my lord, have been withheld. On erroneous ground that, my lord, we are coming in the new scheme of pension. My lord, we have approached this honorable court. The order at, my lord, page number 9. Relevant portion, page number
11.
12. Without expressing any opinion, my lord, only to consider our representation. My lord, even now, they filed a counter affidavit stating that, my lord, they forwarded the proposal to the government and keeping quiet, my lord. My lord, right from 2020, my lord, we are retired. We are finding it difficult to sustain ourselves without retail benefits and, my lord, even pension. Lordship
should
Sever, my
consider?
lord, they are all daily rate employees.
Who should consider?
My lord, the university. My lord,
Okay.
can you look at the university, my lord?
Paragraph 7 of the reply.
Yes.
So consider.
Yes, my lord. We are retired in the year 2020 and 19.
Final order dated 28/3/23 passed. Has received the endorsement dated 16/8/23 stating that the complainant petitioner would be entitled to the pensionary benefits pursuant to decision taken by state government in this regard. So it is, what is it?
Lord, we have replied on 19/12/2023, stating that, Lord, new pension scheme is applicable to the employees because they have been regularized from 14/7/2008. New pension scheme came into effect from 1/4/2006.
Who is regular from 2007? Can you look at the Annex C, my lord?
They are disputing their entitlement.
No, we are not disputing their entitlement. They are entitled for the benefit of new pension scheme.
Not new.
They say only under the new scheme is different.
In fact, we
My
have
lord, the
processed.
very fact, my lord, he is saying is incorrect for the reason. Annex C says they are regular from 1997 with retrospective effect during 2017. He says 2018, my lord.
Assuming. Please read page 12, para 3.
Yes.
Direction is to consider representations of the petitioners in accordance with law.
Yes.
They say old pension scheme is not applicable, new scheme is applicable. You say old scheme is applicable, new scheme is not applicable. We are in contempt jurisdiction. You know our limitations. Arguably, you may have a very good case on merit, but this is not a writ petition.
I follow your lordship what you are
That's
saying. But kindly look at, my lord, in accordance with, my lord, 1/6/2006 onwards, my new pension scheme applicable. We have been regular, the orders, kindly look at the order, my lord, order of regulation says their own order from 1997 have been regularized retrospectively. My lord, now coming out with reason, my lord, 2020 onwards, my lord, nothing is paid to us. And my lord, now they say, my lord, that whatever they produced given to us is not given to us.
What is the payable to them under the new scheme, under the?
That we have processed, my lord, it is in the FD department.
No, that is not complaint. Your specific cases, you are on binary positions now.
Please.
So far as your case is concerned, they are entitled to the benefit of terminal benefits under the new scheme that was promulgated with effect from 1/4/2006. You should pay at least under the new scheme. That you have not done.
May I make one submission, please, Your Lordship? They have to contribute. The employee has to contribute his share for the new pension scheme that they have refused to do.
Lord,
So and I've, 1 minute, sir. I have stated so in my response. There's been no contribution.
Now I have received, ma'am.
But kindly, my lord, may I request your lords one thing, my lord.
1 second. I'm
And
looking
before
at-
your lordship, my lord, specific order is passed before your lord. My lord, there is an order of regularization by them with effect on night. Kindly look at, my lord, page number, only 1 minute, my lord, page number 19. I'm not troubling you. No, that order is now they are handing over. We do not know.
What you have said in this?
Not in this letter, we have clearly stated,
No,
since
we
they
give
have
the
been
proper
regularized
proper
from
message.
14/7/2008. The new pension scheme is applicable, which came into effect from 1/4/2006.
2003.
Six.
My lord, what I request, kindly, my lord, what they're stating now, not, kindly look at page number 19, my lord, for
They
a
are,
minute. Kindly allow me a minute, my lord. Page
Please
number
allow us-
19.
Please allow us also. With effect from which date their services have been regularized?
14/7/2008.
My lord, kindly look at the order of regularization, page number 19. Kindly look at page number 19, my lord.
19.
19. Okay, government, sir, my lord, this column number 5.
Based on the letter, I am submitting.
My lord, serial number, my lord, column number 5, the eligible date of regularization. Lord, you got it, my lord. Column 5. Date of regularization, eligibility. My lord, Mariswamy,
1997. 97, 98, 97.
This is not the order of regularization. My lord, he is now coming out with something, my lord, which is not true at all in a contempt proceeding. Prima facie, my lord, this kind of statement is incorrect. No, I am before your lordship seeking sustenance.
I have said so, but it's even 20 February. How much does it?
1198. 190. So after 90 days, the new scheme.
Would you file your counter?
Please. Without fact checking, my lord, they are irresponsible making this statement. For the 4 years, my lord, we are without sustenance.
No, I am making a.
What kind of a order is being placed before your
I shall
lordship, my
file
lord?
a counter.
This is totally irresponsible. 4 years we are without sustenance, my lord. Copy is not served to us. He is saying 2008, my lord, this is the order.
Whether they are responsible or not responsible, it is for us to say.
True.
We are directing them to file counter.
Yes.
So we are not tolerating any comment.
Yes.
Because in our prima facie view, this contempt is liable to be closed.
My lord, if your lordship.
Still we are asking.
My lord, let them give the copy. I will file the statement.
We don't accustomed to listen comments in the arguments. Just file your counter.
Please.
Just 40 and what?
40. This is a government land, Lord. They are saying, forest land, in fact, deemed forest. They are seeking, Lord, Bodhi and Durasti on the land. I shall file my counter, Lord. 2 weeks time may be granted.
File some affidavit.
2022, this order was passed. The page number 14 may kindly be seen. This is not the forest land, my lord. It's granted in the year 1962. In the writ petition itself, we have made it very clear, and the grant certificate is also produced.
So probably new officer is there now. We will comply with. We will comply with.
The order is 2022.
Actually
Now we are in the
Bodhi and Durasti.
Bodhi and Durasti. It's very simple, and also we have to file the application online.
Next date you.
We'll give time.
2 weeks.
2 weeks. After 2 weeks. So on that day you will comply with.
I'll file counter, Lord, because it's a forest land.
That you can, we said only consideration. That we should have said we considered because of XYZ reasons. This, that, etc.
Confirmation, ma'am. In the cost title.
We will, if you say.
If you are making a statement that
We'll
consider
record your
within
submission
further-
that we will consider the application in time, give an endorsement to him. In accordance with law.
Cost title, my lord, respondent number 6, typographical mistake. Vijayamma is the Tashildar. We have typed it as Vijayamma. Are they?
So course title in relation to respond number,
Vijayamma is there typed.
respond number
6th.
6 is
Sixth.
permitted to be
The memo is
corrected by mentioning the correct name of the incumbent.
correct.
Full stop. These contempt proceedings
On
arise
1/12/2023.
in relation to
affidavit was
directions
also filed,
issued
but,
by learned single judge in order dated 24th November 22 in writ petition number 16033 of 22. It is the following directions which are required to be complied with by the competent authority with respondents. Then quote paragraph 3, bracketed portion on page 14. When the contempt application comes up for consideration today, figures on record, affidavit filed by Tahsildar, who has stated that he assumed the charge.
Now he is from that area to another place.
Point of time, and
They
that
will
he
now
has
consider.
now been transferred. Full stop. While noticing the said aspect, the court asked learned government advocate, Mr. S.S. Mahendra, to respond as to within what time the directions could now be complied with. Paragraph in response, learned government leader stated that the directions contained in paragraph 3 of the order dated so and so shall be complied with within 4 weeks from today, and appropriate decisions shall be taken. The decisions shall be communicated to the petitioner, whom it was further stated. In view of the above statement, we do not see any good reason to continue the contempt proceedings. The statement made by learned government leader, government advocate shall be abided by.
May I request, my lord? See, we have already experienced. If they within 4 weeks,
Therefore,
I may be permitted to file another.
Therefore, failure to comply with the directions as above will expose the content, will expose the respondents to aggravated form of crime. This court has not expressed any opinion of the either side, and all the contentions are left open. It will be agitated if required in the appropriate process.
Number 23, Mr. Satish K.
Appearing for complainant, my lord.
My lords, in this matter, on the previous date of hearing, which was in January, my lords, 12th of January, I have filed a memo, my lords, producing the orders of this honorable court in another proceedings, my lords. The complainant also happens to be an ABT employee, appointment by transfer. And this list, my lords, pertains to his promotion. Now, appointment by transfer, he is also a party in that list. There, my lords, there's a direction of this honorable court not to issue any promotions and publish any list. Now he's seeking promotion in this, and my lords, that order by passed by, which there is a direction to me, my lords. My hands are tied not to provide promotion.
The other connected matter is stayed.
That other connected matter, my lords, there is a direction for me not to promote any of the respondents. He is a respondent in that list, my lords.
You are one of the respondents in that. Now what they can do? Where is willful disobedience? His hands are tied because of the interim order.
My lords may kindly see. That matter is also listed on 26.
So what is that another proceeding? Some different petition?
Yes, yes. And also, my lords, may kindly see page number 2, my lords.
Anyway, he is a party to that proceeding.
Yes, he's responding number
there
30.
your hands are tied.
Yes, my lord.
Which is the proceeding? 858?
My lords,
Appeal number 414 of 2023.
414. Yes, my lords. My appeal is 1211.
What is the stay order?
My lords, that order Operative portion is at page number 5, my lords, the second paragraph. May I read, my lords? Considering that the appellants have raised various contentions and parties are before the court, it would be appropriate to direct the respondent KPTCL not to publish any list pursuant to the directions of the learned single judge without orders from this honorable court.
So that is order dated 27/4/20.
Yes, my lords.
The directions which are sought to be complied with in the present contempt proceedings are contained in paragraph 11. Order dated 9th June 23, passed by learned single judge. Full stop. Therein, the respondent corporation is directed to consider the case of the petitioner for promotion within the stipulated time. Full stop.
My lord, one submission, my lord. May I request to keep this contempt pending, my lord?
Why?
Why?
We can't, because you are a party to that proceeding.
Please, my lord. My lord, I'll take instruction, my lord. Any date may be given. my lord,
Learned
I'll argue, my
advocate,
lord.
Mr.
Shirish Krishna.
I'll take instruction. my
So
lord.
and so appearing for respondent.
Respondent. Accused.
Respondent corporation.
Corporation.
Respondent,
KPTCL.
respondent accused. Comma, when the present proceedings were taken up for consideration, comma, pointed out that in a connected writ appeal number 414 of 23, comma, this court has passed order on 27/4/23, in which it is inter alia directed that the corporation shall not publish any list of promotees. Of promotees?
Yes. Of promotees.
Pursuant to the directions of learned single judge. Without orders of this court. Beside the interim order passed in the connected petition is not only in operation, but it is an admitted position that the present complainant is also a party to the said proceedings. Paragraph. When confronted with the aforesaid factual position, learned advocate Mr. So and so for the complainant was entirely at his receiving end and could not dispute the factual position. In view of the above, it could not be said that the accused have committed any willful disobedience of the directions of the court. In the content in the order brought for compliance in these proceedings, full stop. Accordingly, the present contempt proceedings are dropped.
Grateful, my lords. My lords.
At this stage. Yes, at this stage.
My lords, in 23.1, which is my appeal, my lords, it may be connected with that batch of writ appeals. My lords, subject to that decision, we will take action in accordance with law.
Learned advocate for the accused fairly stated that the consequential actions will be taken by the corporation, subject to the outcome of the.
Lord, may I request
No,
this?
my lords, in 23.1 is my appeal on the same order of the learned single judge in this.
So same order.
That can be tagged along with that writ appeal, my lords.
The other writ
414.
appeal. 414.
414.
This appeal. Of 2023.
23.1.
Yes, my lords.
So to be placed with writ appeal 414 of 23.
I request this, my lord. Liberty may be reserved to the complainant, my lord, after disposal
You
of.
said
the-
at this stage.
Please, my lord. Please, my lord.
Yes.
Number 24.
Grateful.
First one.
Appearing for the appellants, my lord. Respect to the lordship's previous order. Lordship is. Respect to the lordship's order in the previous date, my lords. The respondent number 16 is no more, my lords. And the notice to the notice with respect to the respondent number 16 is dispensed with respect, since she is no more, my lords. I may be permitted to file a memo of deletion of the party since her LRs are already on record. And I may be permitted to carry out the necessary amendment in the course of a week, my lords.
All LRs are on record now.
Yes, my lords.
Of respondent number?
16, my lords.
Who are they? Which respondents represent the estate of the deceased?
Respondent number 16s are represented by respondent number 18 to 20, my lords. 18 to 20.
So 16 is Srimati Nagamma.
Yes, ma'am.
She is right.
Yes, ma'am.
18 to 20. No other LR. All LRs are here.
Yes, ma'am. They are the, as per the instructions, they are the only LRs, my lords.
Who are 17 to?
My lords.
Who are the LR?
18 to 20.
18 to 20, my lords.
18, 19, 20.
Since 17 is also no more, ma'am.
17 also.
17 is already dead, my lord. Since we have already brought to the lordship's concern that 17 is
So no more.
no more, my lords. I have filed a memo for deletion of 17. That is already taken on record.
You just record and that is.
17, it is already noted in the cost title
First title,
itself.
it is noted itself.
It is noted in the cost title.
When the present writ appeal comes up for hearing, learned advocate for the appellant submits memo dated 18 to 24, in which it is mentioned that respondent 16 died during the pendency of the writ petition, and their legal representatives are respondent 17 to 20. It is further stated that respondent 17 has also died, and the living heirs are respondent 18 to 20. Correct. Since the heirs of the deceased respondent 16, who are respondent 18 to 20, are already in record. A formal application for bringing them on record is not necessary. However, they shall also, our respondents 18 to 20 shall also hold the capacity of heirs and legal representatives of deceased 16, in addition to their own individual capacity. With the effort, the course title shall be amended
The course
accordingly. Respondent 17 shall stand deleted.
Yes, ma'am.
The fresh memo of writ appeal as amended above shall be supplied within 10 days. Don't write. No fresh memo. So we post it after
Next week, ma'am.
2 weeks.
Placements.
Number 25,
My lord,
Ravi
the
Shankar K.
appeal along with the contempt may
Hearing
be
for the
taken up.
complainant.
Your appeal.
My appeal.
Your appeal is allowed.
Can you delete one?
No, my lord, it's listed today.
Together.
Or to be listed.
No, it is listed today, my lord.
Already listed.
I may be permitted to make my submission.
Serial number?
25.1, my lord.
All. So we take up that. We take up that appeal.
My lord, there is, my lord, the learned single judge, while passing the order, my lord, refers to another writ petition which has been disposed of, my lord, against which the state has preferred an appeal.
Stay is also there.
My lord,
No stay.
I wouldn't know, my lord, that writ appeal may be connected along with this 815 of 2023.
That is still pending.
Yes, my lord.
My lords.
Together. Notice is ordered in that matter.
My lord, I don't.
My lord, one submission, my lord.
Our learned additional government advocate, Ms. Nilofer, for the appellant, appellants. Notice to the
My
respondents.
lord, my lord, I'm
Returnable
only
on-
aware of the content matter, my lord. I'm not aware of appeal. So I'll get the instruction from my senior.
No, where is she?
Returnable on 16th April. The present contempt application shall be listed along with the appeal on 16th.
My lord, this appeal may be connected.
Called along with another appeal. Appeal number?
815 of 23.
Writ appeal number 815 of 23 shall also be listed
Yeah, obliged.
along with the opposite to proceedings.
Obliged.
This is number 26. Padmanabhat.
My lord, appear for complaint in this case, my lord. My lord, with regard to the aided period of the service benefits, my lord, it's been settled, my lord.
We have filed complaints affidavit, Lord, stating that, Lord, so far as aided period, this is pertaining to Act 7 of 2014, Lord.
Yes, my lord, that
7 of 2014.
The writ appeal, a batch of writ appeals are pending, Lord.
Lord,
A
but-
special bench headed by your Lordship.
My submission
It is
is
2476 of 2015. We have filed a complaints affidavit stating that, Lord, so far as the aided period is concerned, Lord, we have settled. And in 2476 of 2015 and batch of matters.
So this matter now cannot be taken up.
my lord, my submission, my lord.
And there is an interim order in that.
My lord,
Special bench.
Special bench
comprising
headed by
myself.
your
it
Lordship.
is there, my lord. But the same writ appeal is not listed for final hearing, my lord. Kindly be same said main writ appeal, my lord. Kindly be listed for final hearing, my lord. It maybe get disposed of, my lord. Sir, am I hearing, my lord? My lord, am I audible, my lord?
So far as undisputed amount is concerned, Lord, we have settled.
You have already paid that.
We have already paid. Therefore, my request is, Lord, this contempt may be closed for time
One
being.
period, my lord.
Subject to the outcome of 247.
Am I audible, my lord? My lord, am I audible? My lord, am I audible, my lord?
Yes. You have been paid admitted money now, but the judgment, the substratum of the judgment is nullified by a legislation. Validity of the legislation is being looked into by coordinate bench.
Yes, my lord.
Where incidentally, I happen to be one of the members.
My
So now nothing can be done.
my submission is, my lord, the said appeal, main appeal is not listed for final hearing, my lord. My request is, my lord, kindly be listed, the said appeal listed for final hearing and get disposed of, my lord. Because lot of employees are not getting the pension because of pendency of this writ appeal, my lord. My request is the only thing. And so many employees are expired, my lord, in between the pendency of the writ appeal, my lord. Kindly fix any date for hearing the writ appeal, main appeal. And this contempt petition may be listed along with the writ appeal.
This contempt alleges violation of a learned single judge's order dated 10/7/2015, whereby the subject writ petition 12613 to 12644 of 2015 came to be disposed of with some direction to the government that related to payment of monetary benefits. First, learned counsel, learned EG appearing for the respondent accused submits that the substratum of the said judgments having been taken away by Act 7 of 2014, there is no enforceable direction in all these matters. First, he further submits that the virus of the said act is being examined by a coordinate bench of this court wherein one of the judges of this bench happens to be a member, KSTJ. First, therefore, he seeks dropping of the proceedings. First, next, having heard the learned counsel for the parties and having perused the petition papers, we find lot of force in the submission of learned counsel appearing for the state, and therefore we do not propose to take any action in respect of alleged violation of the order of the learned single judge till the decision is taken as to the validity of the subject legislation in the pending writ petitions, wherein it is said, there is an interim order as well. First, with the above observations, these proceedings are dropped with liberty to the petition complainants to seek revival in the event, depending upon the result of the coordinate case. Learned AGA submits that the undisputed amount is already paid to the complainants.
Submission. Similar identical, similar contempt petition which writ appeal is pending or were tagged with the writ appeal, my lord. This contempt petition.
We have kept open after those proceeding concludes.
Number 27, Mr. Shrikant Patil K.
And in this matter, I seek 4 weeks time for complaints.
Complaints of writ appeal also.
Lord's subject matter of land was under acquisition. Acquisition was quashed. Then BDA went in appeal. Appeal was, my lords, a liberty was granted us to file a review petition. SLP liberty was granted us to file a review petition.
Very well.
Review was filed before the division bench. Notice is being ordered to the respondents. That is one matter, one aspect of the matter. And against this order, we also preferred an appeal. BD also has preferred an appeal before this court.
Is this now?
Direction was not.
No, my lords.
Direction was not issued to
My lords,
BDA.
when the order was passed by the learned single judge, review was not been filed.
You were BDA.
I represent BDA because
Direction was given to you only.
no direction was given to DC. DC has declined the request of the landowner on the ground that BD has not issued NOC because the subject matter of land was under acquisition proceedings. My lords, in the light of subsequent event, my lords, a review petition is filed against the order where quashing of the acquisition, and notice has been ordered by this court, my lords. Now, my lords, in any event, if I succeed in a review, if an acquisition which was quashed is reversed, then, well, of course, my lords.
Nothing is going to happen.
No, the
Nothing
reason
is going to happen because
yes,
even after acquisition,
yes,
you will take the development activities treating the land as non-agricultural. Nothing is going to happen.
No, the reason is, I'm sorry.
I only said in different words what the apex court has.
No, my lords, once acquisition gets upheld,
yes,
acquisition gets upheld, land vest with the BDA.
Correct.
BDA becomes the owner of the property.
But how that is going to affect the conversion?
Conversion, because if he is not a owner of the property, once the BDA becomes, once the acquisition is upheld, the land vests with the state.
Council futuristic event, we don't take into account while dealing with the contempt.
Great.
That is the whole thing. Whatever rights.
Subject to result of review.
So,
Conversion has to happen.
no 4 weeks, 2 weeks.
2 weeks you have to report. How many, you just want to
Just you
harass
to
the litigant or what?
Issue and you say endorsement or order.
There is a deemed conversion.
That's the order. Actually, it's a deemed conversion.
Despite orders, they are not doing
If
this.
decision is not.
The division bench of Dharwad High Court has held. It's actually deemed conversion.
Deemed conversion.
Even then you don't want to take, even despite orders of the court. What kind of officers we have, we do not understand. Next time we will not be, that will be little, tell your officers.
I will not be tolerating your inaction. 2 weeks, 2nd of April. Learned government advocate Mr. Mahendra 6 time for 2 weeks to comply with the direction.
Number 28, Uday Kumar L. Uday Kumar RL.
I filed the objection, but there appears to be enable office objection.
But this is
By
second,
oversight.
second contempt. Second contempt.
Second contempt.
How second contempt?
No, it will
Contempt of
not be, it will not be a contempt, but what I am pointing out is the objection statement, those annexures are not attested by the.
No, no.
person.
Where Honorable Chief Justice is asking counsel for
There
the
is second
complainant.
Second complaint, my lord. It is the undertaken given by the contemner bank. Annexure B, my lord.
Annexure
B.
B.
Yes, my lord. Page 18, my lords.
Page 18.
Para 7, my lords. May I read, my lords? Para 7 of the page 18. That state that since there was a difference of legal opinion, the board met on 22/9/2022 and decided to implement the order dated 8/1/2021, and thereafter the order dated 28/10/2022. The accuser passed the orders immediately. Accused provided equal pay to equal work to the 18 persons, including the complainant, as per the order of the apex court with effect from 1/4/2021. Madam. This is the issue, madam. They themselves come before the court and filed an affidavit. They are going to pay from 1/4/2021.
Therefore, proceedings were dropped.
No, this done on the basis of even that is please, my lord, that is also not fully compliance of the order of the single judge. Anyway, that liberty was given for the complainants to go with appropriate this one. Such being the case, my lord, they are going to give for 1/9/2023. How can it be, my lord?
Objection, Burley. Let his objection.
Put your house in order.
Please.
Date may be given, my lord. Next.
3rd April. Please.
But 29.
Question relates to applicability of new pension scheme. There was a common order passed by the learned judge. The companion writ petition, the writ appeals have been admitted.
Court fee is not paid. Court fee is not
It's a
paid.
common order, but.
Court fee is not paid.
No, my lord, here, the court fee, my lord, I have submission to make, my lord. Your lordships may please see, the writ proceeding rules, the officers raised an objection. Their objection is like this, my lord. There were a large number of petitioners. Each of them had paid 100 rupees and the writ petitions were filed. The learned judge passed a common order. Against that, we have filed writ appeals. Now, my lord, in the writ petitions, there is a provision for each petitioner to pay separately. Whereas in the writ appeal, my lord, the Court Fees Act does not say I must pay separately. Kindly produce the Court Fees Act.
I think there is one division bench judgment which has considered this aspect of the argument and held against you.
I will examine, my lord, and pay.
They have to pay that.
Because the entry, my lord, in the Court Fee Suits Valuation Act, my lord, is entry SA, which simply reads like this: appeal petition to the High Court from an original judgment, decree or order of a single judge in exercise of powers. Fee payable is 100 rupees.
For if you are filing appeal against common order,
Yeah.
then for the purpose of court fee, separate head will be counted. There is a similar such judgment by Justice K.S. Swami, great judge of this court.
No, no, these are the writ petitions were by different sets of people.
Correct. Each of the writ petitioners had paid.
They had paid.
Yes. That if you want to challenge,
Yeah.
the same amount should go to the exchequer of the state.
No, that is not there in this in section, my lord, but I leave it.
Look into, just look into. I will also look into.
Please,
Just
Lord,
you also.
may I request your lordships, my lord, to connect it with the appeals which are already admitted
10th April.
against the same common order. There is already an admission and interim order.
The court fees you resolve, then we'll admit. It's bound to be admitted once it is cognate appeal is admitted.
Pay court fees.
Lord, your lordships may direct me to pay, my lord. I am a state body. I will pay.
The learned advocate for the writ, this is appeal. The appellant states that the court fee as required to be paid.
Be paid in 2 days.
As per the endorsement shall be paid within 1 week.
2 days.
Within 2 days.
Please.
Full stop. he further states that arising out of the
Very same order.
judgment and
Yes,
order
ma'am.
of
Again,
class
I
of
pray
the-
for the-
and
I
the
appear
writ
for
appeal
the
is admitted.
respondent. Yes, ma'am.
In that
May-
way, this appeal is also admitted to be listed with the said writ appeal number
1252 of 23.
1252/83.
1252 of 2023. It's admitted, my lord, on 24/4/24.
Interim order is.
Interim order is there, my lord.
But.
I've given
may
a
I make
copy
one
of the
suggestion?
order.
I'll,
Yes.
I appear for
Yes,
the
Professor.
contesting respondent. Now, I have no objection to connect the matter and to post it along with it, but I may be heard on the question of interim prayer made by. The reason is this: 7,525 linemen. 7,525 linemen of the erstwhile Karnataka Electricity Board, who were employed much before the new pension scheme came into effect and have been subsequently absorbed.
Professor.
Sir.
Professor.
Sir.
I have a small submission.
Please.
A division bench of this court in 1977 said, where interim appeal is admitted and interim order is granted in one set of cases, it cannot be denied in other set of cases. 1977 writ appeal. It's unreported.
What is the
judgment.
interim order?
Sir, there is
Interim
a
order is stay of the operation. Lord.
there is a distinction.
Then judge, my lord, directed.
Automatically applied to this process.
Sir,
Yes,
there is
ma'am.
there is a distinction.
Then judge has granted stay of.
There is a distinction between the appeal that has already been admitted and this appeal. For the reason we are governed by a settlement, a tripartite settlement.
Mr.
which-
Counsel, even if we don't pass the order, the judgment will remain stayed by virtue of the order passed in the cognate appeal.
If I may say so with respect, if I may say so
Early
with
date,
respect,
Professor,
that
we
was
can
not
fix-
an appeal.
say
That was
date
not.
whichever
Date is
one.
fixed, my lord, by the honorable
All
bench
that-
as 24/4.
24/4.
Yes.
We will dispose of the matter same day. Hopefully.
So we'll
I'm
say
ready.
that-
I'm ready to address it.
Please.
The interim order passed in the cognate appeal shall also operate to govern the rights of the parties, the present writ appeal. On this. Both the appeals shall be listed together on 24th of April.
Please.
Number 30.
Wait for the.
Direction to the respondent to consider my representation within 3 months and pass appropriate order in accordance with law.
What's the order?
My lord, we have considered the representation. We have requested the complainant to give us information so that the allotment can be done. The complainant is the legal heir of the original allottee, and she's only the wife. We want to know the details of the other legal heirs so that the allotment process can then be taken forward. We have written a letter to the complainant. my lord.
To furnish necessary
Du-
information, they will
During
consider.
during the pendency of the writ petition, my lord, the original petitioner passed away, my lord. The legal heirs were brought on record, and thereafter they are very well aware who are the legal heirs, my lord.
In the order.
In the
they
order
mentioned
itself, their name is mentioned.
1A, 1B, 1C.
Yes, my lord. Yes, my lord. They are the only legal
What has
heirs.
to be done, my lord, is that now since the allotment is being sought by only one person,
Yes.
the other 3 persons also have to come forward. They have to
They,
execute
they
an
can
affidavit and say
they
whether.
can allot in favor of all the persons, my lord. There is no dispute.
Joint allotment.
Yes.
So they all
yes.
have to come.
Permissible.
It's permissible, my lord.
Then
So
they
they
are
all.
saying that it can be allotted to all the 3.
That's all we are asking, my lords. So their information, their.
All right. Now you are saying that you will be making allotment.
Yes, my lord. We
to
have said in
every
our.
one of the deceased.
We have said in. May I pass this on? My lord? We have said in our letters.
Within what period you will do that?
The moment they give information, my lord, we'll immediately start processing it.
We are asking you. We were immediate, our immediate.
3
maybe
weeks
for-
time I kindly be granted, my lord. So that from the day they provide the information, my lords.
Within 3 weeks.
They have to, my lords. The reason why, my lords, is that
Was
they
directed
have.
by learned single judge in his order dated 15th November 22. Was to decide the representation of the petitioners dated 9/4/15 and 23/12/17, and to pass the appropriate orders the orders, the representation were to be are to be considered, and the orders on their own, orders thereon. Record we passed by the competent authority, the Bombay of the Bangalore Development Authority.
Yes.
Please, my lords.
Full stop. The grievance of the paragraph petitioners was with regard to the allotment of alternate site in lieu of site number 266. Carved out of survey number 21, Upasandra Rajmahal Vilas, second stage, Bangalore.
The same layout you are granting.
No, my lords. This, it is in, it's in a different layout, my lords.
The heirs of the original petitioners were the original claimant.
Original allotee, my
For
lords.
the petitioners in the writ petition, paragraph. Learned advocate Mr. Swanso for VDA appears and states before the court that the representation of the petitioners have been considered and the VDA has decided to allot.
May I submit this, my lords? I'm sorry, my lords. We have, my lords, on 23 to written a letter to the complainant requesting for the information so that we can actually proceed and pass a necessary order for allotment, my lord. Allotment, my lords.
Stated that the VDA has written a letter to the petitioners seeking certain information. Full stop. In response to this proposition, learned advocate Mr. So-and-so for the petition stated that the necessary information shall be supplied to the VDA within a period of 2 weeks from today.
Within 1 week, my lord.
Within 1 week from today. Full stop. Once the information is supplied, the VDA shall take necessary decision as directed in the order dated 15th December 22 with regard to the allotment of alternate land to the
alternate site
petitioners.
Please.
The decision shall be taken within
3 weeks after that, my lord.
date of receipt of the information. Full stop. Since the aforesaid commitment is made before the court by the VDA.
My lord, I'm sorry, my lord. I'm sorry. We will consider, if your lordships may kindly note it as an order, my lords.
Order only.
Since rather than a commitment from my end, because if your lordships
Commitment to consider.
Commitment to consider, my lords.
The aforesaid commitment.
You know, there is already an order, my lord.
To decide the representation of petitioner regarding alternate site, the contempt proceedings are closed.
Please.
Full stop.
1987 allotment, my lord. 1987 allotment.
4 weeks therefore, after you supply the information.
My lord, only request is that let this contempt be kept pending, my lord. That is my one request, my lord, because otherwise this allotment will not be complete.
Which may be, in any decision which may be taken pursuant to these decisions shall furnish fresh cause of action to the petitioners to initiate, if required, appropriate proceedings in accordance with law.
Oblige, my lords.
Number 31, Mr. Raja Ramesh.
Please, ma'am. In the instant case, my lord, while passing the order in repetition, my lord, the National Court directed to maintain status quo, my lord. My submission before the National Court is that, my lord, day by day they are constructing the residential house in my property. Kindly turn page number 20 for a moment, my lord. Paragraph number 5. Last 5 sentences, my lord. May I read, my lord?
Are they constructing now?
Yes.
Not on the property, my lord, concerning which the suit lied. My lord, I have filed my statement of objection. A report, my lord, have been submitted by the jurisdictional panchayat, specifically stating that it is not in the suit property that the construction is being put up, and in the other property which belongs to the accused here. My lord, that I have produced as annexure R3 with my statement of objection.
The petition related to which property? The suit property, which is the property comprised in the suit?
My lord, please. My lord, the property, my lord, which is subject matter of the suit, bears danger number 624.
Yes.
Property number, my lord, is 628. That, my lord, will kindly get it page number 49 of the contempt petition. Plain schedule.
Suit is pending.
Yes. Pending, my lord. Defendant witness is going on.
How to decide whether it is in that property or this property?
It's very difficult, my lord. So for that reason, or otherwise, I may permit.
You go before the trial court and take up this contention, this
Yes.
complaint. We can keep open all.
39(2)(a). Please,
Whichever.
please.
While disposing of the writ petition on a single judge of this court by order dated 20th June 2023, inter alia directed that the
Page number 20.
writ petitions. The two writ petitions number 24642 of 22 and 247/2022 shall be decided expeditiously. At the same time, the parties were directed to maintain status quo in all respects in relation to the suit scheduled properties and the written statement scheduled property. The trial court was also directed to dispose of the suit expeditiously on or before 21st December 2023 without being influenced by the findings and observations. Paragraph. What is complained of in this contempt proceedings is that the status quo has been violated and the constructions are being put up. Full stop. It is the stand of the accused that the construction are not put up in the scheduled property. Full stop. It would be in the disputed realm of facts as to whether the construction is put up in particular property or other property. The court cannot go into the said aspect in the contempt proceedings. Furthermore, the original proceedings of civil suit are still pending. Full stop. Both the aforesaid reasons, paragraph, weighs with this court to require the complainant to approach the trial court in the suit proceedings to work out their rights in relation to the grievance alleged in this contempt proceedings. All the contentions of both the parties are open, and this court does not express anything on the merits. The present contempt proceedings are accordingly closed. Are closed with the aforesaid observation.
Number 32, Mr. Vishwesh, yes.
Appeal for the respondent number 1, my lord. I appeal for respondent number 2 to 4 also. I appeal for the respondent number 1. I undertake to appear for respondent number 2 to 4 also.
All respondents.
Time.
2 to 4 months to appear.
You want to appear or you want time?
I undertake to appear, my lord. During the course of the day, I will file the memo of appearance.
Need time to file?
Yes, my lord. I will, within 1 week, I will file the statement.
So after 10 days, when indeed. It is PIL.
Okay, yes, my lord. The PIL. Non-inclusion of certain questions related to disabled person in a
Yes,
survey.
yes.
Number 33, Mr. Shishidhar S. Karamadi.
Pay for the respondent.
Complaint, my lord.
So we will be complying.
No, Lord, kindly, Lord.
Commissioner.
Lord, the endorsement is issued to which the complainant has also filed a reply before the BDA. Lord, we have said, Lord, if you
Consider the representation.
consider the representation, it
And
has
you have
been
considered and informed him
considered,
also.
endorsement
Lord.
has been issued to it.
May I make my submission, my lord? My lord, in the endorsement, they have demanded interest at 18% for 90 days, and again 21% for 8,539 days, my lord.
Whether direction not to levy any interest is there,
I will have to,
then you have to work out. We cannot undertake critical examination of the endorsement.
Lord, my apologies, my Lord, it is in vernacular
The
language.
grievance of the complainant, who was the petitioner in the writ petition, was that the sale deed was not being executed by the authority pursuant to purchase of the property by the complainant in the auction. The court, the not called learned single judge by order dated 13th October 23 directed to consider the representation of the petitioner in that regard, to take an appropriate decision within 8 weeks. Full stop. Today, when the contempt proceedings, it is the aforesaid directions which are brought under the contempt jurisdiction of this court. Paragraph. When the contempt application came up for consideration today, learned advocate Mr. So and so for the respondent accused produced a memo dated 13/3/23 stating inter alia that the endorsement dated 16/2/24 has been issued by the Bangalore Development Authority, and the copy thereof is also produced on record. Full stop. The said endorsement dated 27/2/24 reflects that that the representation is decided, and therefore, decided, therefore the directions are complied with. Full stop. In the aforesaid view, the contempt proceedings are required to be closed. However, if the complainant has any grievance or reservations about the endorsement made, the complainant is at liberty to institute appropriate independent proceedings in accordance with law, in respect of which this court does not express any opinion on merits.
great, my lords.
My apologies for not providing translated copies. My apologies. My apologies for not providing the translated copies. Okay.
Number 34.
My lord, I have, there is an office objection raised regarding furnishing of translated copies, my lord. My lord, only limited question in this case, my lord, is regarding mutation entry in the name of, in my name. Though Assistant Commissioner and the Deputy Commissioner had held that mutation to be carried out in favor of me, the learned single judge, in view of pendency of the civil case, directed the matter decision with regard to mutation entry be decided before the civil court. But my only submission is only limited request before this honorable court is that, my lord, mutation entry be restored in the name of my father. Other than that, I am not making any submission. My only request
is still pending.
Yes, case is still pending. The brother had changed his elder brother changed the kata in his name without notice to me.
All right,
We are
you
all
party-
brothers, my lord.
Are you party in the OS?
I am party in the OS. Only my limited request is father's name may be shown, my father's name, and we will decide before the trial court. That's the only request, limited question I am coming
OS.
before the.
Is the plaintiff, he has filed the suit. His suit is pending.
So we can only modify the order to the extent.
Only to that extent, my lord.
There shall be endorsement in the record that the entries will be subject to final outcome of the civil suit.
Yes, my lord.
And for the respond number 1 and 2, my lord.
Undertake to file wakalat for respond number 1 and 2. Still I have not filed the wakalat. And my lord, the mutation entries earlier was in our name.
Pass the orders.
Obliged, my lord.
The mutation entries were earlier in my father's name. Respond number 1 husband's and respond number 2 father's name.
But we are maintaining the order as
Yes.
of learned, except this
Obliged.
Subject to outcome of this.
innocuous modification.
Obliged.
Obliged.
38. 34.
Number 35.
For the appellant in this case,
Koda.
this honorable court in writ appeal number 65 has directed to connect this matter and to be heard along with that, my lord. This honorable court has directed in writ appeal number 65 to connect this writ appeal to be heard along with that, as it is a common.
So that appeal is coming up when?
On 18/4, my lord,
18/4. It was stated by learned counsel for the appellant that writ appeal number 65.
65, my lord. I have produced it along with the memo, my lord.
24. 360.
The present one is 360, my lord. It was ordered in writ appeal number 65 of 2024.
65, 2024. Is a cognate appeal.
Yes, ma'am.
And that both are required to be listed and heard together. In that view, this writ appeal number 360 of 24 shall be listed along with writ appeal number 65.
My lord, one more submission.
On 18th of April.
One submission, there is an office objection, my lord, along with the council submission, it has been put up. Color copies, color photocopies has to be produced, and that was the respondents' photos that had to be produced.
Photo, original photo.
The respondents had produced it along with their.
So, which objection regarding supply of colored photo? Is dispensed.
Submission.
For 36. Sajay Jain.
Lord, the appellant was a writ petitioner before the learned single judge. Lord, the appellant is a Schedule A Central Public Sector
But before my
Enterprise.
learned friend begins, there is another writ appeal arising out of the common order passed by a single judge. And I'm told, that is not listed. So would your lordships consider taking both together so that we can make our submissions together, my lord?
Both together.
There was one writ petition.
In fact,
filed
that
by
was
the
also
appellant.
moved, but there were some office objections, which is
there
why
was
it is not listed today.
There is one writ
Writ appeal 359.
So at the joint request of the councils for the parties, this writ appeal shall be is required to be listed with the cognate writ appeal number
359.
359 of
2024.
Ordered accordingly. Both shall be listed on which date?
Friday.
In that, any date is fixed in that appeal?
No, it has not
Not
been.
comment
Would your lordship take on Friday or Monday, my lord, one of the 2 days?
Either way, whatever suits my lord.
18th, not Monday. 18th Monday. Very well, I'm grateful.
19th.
What is this? What is this?
19th. My
20th. 20th.
What is the subject matter?
20th.
Subject matter is?
Subject matter.
Land acquisition.
Land acquisition. Okay.
The writ petition, my lord, has been dismissed. Because
My lord,
MRPL, my lord,
Friday. This Friday. Can it be this Friday, my lord?
Friday.
Friday.
Money
Very well, but then 20th, my lord.
20th.
20th. Let them not, there is, we have sought for stay of dispersal of the amount. No, it's we have sought stay in the other matter, which is
Both
the
are senior
connected-
councils entitled to fix your date.
gentleman's agreement.
Great.
20th.
Great.
So my brother is saying that love at first sight.
When she was from chief state. When she was from state of our chief justice. Honorable Chief
Yes,
Justice.
Lord. Yes, I know. Of course.
Port fee objection to be.
That has been paid. I am instructed that it's paid. Grateful.
Number 37.
Lordship, my kindly They grant me 3 weeks time to, rather 2 weeks time to comply. The translations are there. May I also rake another indulgence? There's a connected writ appeal, my lords, 978 of 22 listed on 1st of April. I kindly request your lordships to tag this along with that.
Identical matter.
Same
order.
Same order, my lords.
So to be listed with
978 of 22, my lords.
978 of
22. 2022. I'm sorry.
to be listed with writ appeal number 978 of 22, which is stated to be cognate matter on
1/4.
on 1/4/24. Full stop. The office of objections in the present appeal shall be removed by the next date.
Please, my lords, obliged.
Number 38.
Appearing for appellants in serial number 38 and 38.1 matter. These both appeals were dismissed on 5/12/2023 for the non-compliance of office objections, my lords. My lords, these both appeals were dismissed on
The writ appeal, both the writ appeals came to be dismissed on account of non-removal of office objections
Yes, my lord.
within
And
the
the very
time,
next day I
within the
filed
time
it.
stipulated, as reflected in order dated
5 December 23.
5th, 5/12/23. Full stop. The prayer of learned advocate for the appellant is to restore the appeals,
Yes, ma'am.
who at the same time also assures the court that the office objections which are required to be removed shall be removed within
1 week, ma'am.
2 weeks from today. Full stop. In view of the above statement and in view that the appellant should be allowed to contest the appeal on merits rather than being thrown out on technical ground of non-removal of office objections, both the appeals are restored to their original files. However, on condition that the appellant shall pay cost of ₹1,000
Much
in each
obliged.
case to be given to the
My lords,
library,
my lords, may I make one submission? my
your
lords?
own association for books.
My lords, I want to make one submission, my lords. In the previous hearing date, this honorable court directed me to permit the comply office objections, my lords. I went to the pending branch and I asked them, they said clearly there is no office objections left, my lords. Now they have raised new office objections, my lords.
So then ₹1,000 in total. Not 2,000 because of last submission. To be paid within 2 weeks.
Much obliged, my lords.
IA for recalling is allowed in both the cases.
Number 39. Remaining matters.
May I please?
Yes, in this matter, your lordships are here.
Lordships wanted to
No, it
read a
appears I
judgment of
was-
the Supreme Court.
I am disabled.
Yes.
This matter.
Why is it disabled?
Not to be placed before the bench where one of us into the Regulator, Honorable Mr. Justice Nadix, Regulator is a member.
Number 40. Appeal by government.
This is a state appeal, my lord. This matter requires to be heard. It is with regard to grant in aid of teachers, and it emanates from the learned single judge's order. This needs to be heard, my lord. I'd like to place citations and with regard to the support of what the state stands is. The issue pertains to arrears to be given to these grant in aid teachers. They have been shifted to another school already, but the arrears from the date on which the withdrawal of grant is done to when they got admitted into another institution is what is in question.
In earlier institution also, it was aided institution.
My lord, this is a school which has shifted 4 times. And these teachers, now the withdrawal has happened for the institution as well as the teachers. So therefore, the question over here, my lord, and they have been shifted to other institutions.
Which
The
are
teachers.
aided now.
Yes, yes, aided.
As on the date they were shifted,
Yes,
whether the institution from which they are shifted,
was not functioning, was not
was it,
functioning.
was it aided?
It was aided. It was aided. So the aid has been withdrawn and the school was not functioning properly. And therefore, the report and all is there, my lord, of the BEO. Next week, if your lord.
Similar matter we were treating.
Yes.
I vaguely remember. Similar matter was there. Do you remember?
There's one matter which the learned single judge has referred to, that is Shamlata Singh. That issue was different. Over there, the school was functioning. Here, the issue is different. There's one more case, my lord, with regard to this issue, Writ Appeal 2143 of 2006, decided in 2007. That is the CPI versus Cecilia Rodriguez. I have only one copy of these judgments, my lord. The no pay, no work.
Appeal heard learned additional.
Please, my lord. In fact, the stay has been granted to the learned single judge's order.
Krishnappa for the appellant state. The writ appeal requires to be admitted in the case and circumstance case.
Any
It is
date, my
admitted, to be listed for final hearing.
Please.
In the last week of, in the first week of June.
Anytime earlier, my lord, because it's earlier. Last week of this month.
Earlier, you can only fix the date, not here. Whatever date. You choose your date, we'll fix, not
Please, my lord.
after 8 weeks. After
June,
eight
June.
weeks.
Please.
So immediately on reopen?
Yes.
Please.
Immediately
Please.
on the reopen, after
Please.
vacation.
Much obliged, my lord.
Efficacy. Unless these rules are laid in the house, they will not take effect. That terminology is that they will not take effect. If rules are paying procedure, say,
Number 42, Mr. Vinod Kumar M.
For the contempt complainant, my lord. My lord, the husband, my lord, was directed to pay the education expenses of one of the child, my lord, that he has disobeyed, my lord. The order of dishonorable court is found in paper, my lord. 29, my lord. 29 of the contempt petition. The petitioner husband is directed to pay the education expenses of one child from the academic year 2029. Till today, my lord, he has not honored the order of the single judge, my lord. And during the pendency of the petition also, my lord, he had undertaken to pay the education expenses of one child if the wife pays the education expense of other child. That also he has not.
All learned advocate, Mr. So-and-so, so-and-so, propose the complaint notice.
Much.
Will respond and return on 1st April.
Much. Much.
End service. No.
Processes, reports.
Much.
I made an application for implementing. The matter relates to selection to the KPTCL of assistant engineer, junior engineer. The lordships have permitted them to issue appointment order subject to the result. We are one of the selected candidates, Lord. We would like to come on record because we will be affected by the final result in this case.
Lord,
Because
there
the
are,
entire process of selection is under question.
My lords,
How will you be affected by the
Because
final
our
result?
appointment, my lord, is under question here.
we have not
Entire
questioned
selection process.
what has happened in this, my lords. Certain key answers were published by the KPTCL. On the basis of expert committee report, they found 3 answers to be wrong.
This is for promotion.
No, direct recruitment, direct recruitment. Now, my lord, there are 400 selected candidates. This process is,
There is already an order.
nobody can
Heard.
claim equity.
Matter was heard and there is an interim order, detailed order passed. My lord. Could you lordship peruse that now? Matter will have to be finally heard. The interim order, my lord, is 7/2/24. Very detailed order has been passed by the Honorable Division Bench.
This is actually, today it is set down for final disposal.
We have,
With the direction to the Education Authority to place the expert report before this honorable court. At this stage, this years coming up, they are only to intended to delay, my lords.
No.
Because there are, they were not, they were not aggrieved when the revised answers were published. They did not question it. Today, my lords, they want to come and delay this proceedings.
There is no
Kindly
question
see the
of-
conditions
Initially,
imposed.
there was a stay. Then on the last occasion, it has been modified. Only question is whether it is correction of an error.
Any appointment will be made subject to result, my lord,
That
and
has
they
been
have
made.
also, my lord, said that no equities will be claimed. All full protection is given. Not my predicament is not. I appear for the body, my lord, which is recruiting. The examination is conducted by the examination authority. I am keen, my lord, because I don't have staff. Out of 505 posts, select list has only got 401 posts. So I requested Honorable Court to permit me to finish the appointment. They'll still be, my lord, more than 100 posts, nearly 100 posts will still be vacant if they succeed. my
That
lord.
interim
It
order
can always
has-
be worked.
They have been permitted to make appointments. I have not questioned it. Till now, they have not made appointments. In spite of, they said, we are in a great hurry, then even thereafter also 100 posts will remain vacant. We will
Being issued
accommodate,
today,
nobody
ma'am.
will claim any equity. That permission has already been given to them.
So
The
you have
present
appointed
application, my
404.
lord, is would like.
We had to verify,
come
my
on
lord,
record.
all the original documents. Appointment process is done. Today or tomorrow we'll be issuing. They will join immediately.
That will be subject to outcome of the.
Subject
writ-
outcome. The Honorable Court has made it very clear, my lord.
No equity and.
No equity, subject to outcome. Whoever is appointed cannot plead any equity. So, my lord, our difficulty is,
We have prepared some merit list.
my lord, the main contention was this, my lord. There was a examination conducted. There were some questions.
Key answer.
There was a cutoff date for key answer objection. Some objections were received and considered.
So you have prepared a merit list? on
Yes,
the
I have
basis-
prepared a merit list.
So is it possible to find out a segment of the candidates who are eligible to be appointed?
Yes,
irrespective of
That
the
has
outcome
been
of the-
done.
No, that has been done. My lord, their grievances.
Kindly-
No,
Sorry.
No.
Sorry.
Independent of the outcome of the proceeding.
Independent of
May-
outcome of the.
No, my lord, their grievance is this, my lord. They say that if the original cutoff date was kept, there were only 501 candidates. Now, by extending it, you have increased it to 636. So the scope of examination has gone wider. That is their grievance.
no, that's not.
They should not have gone wider.
That is not my grievance, my lords.
Maybe just.
Of the writ petitioner's grievance.
My lords,
If,
That is also not the grievance.
maybe just, that's not at all the grievance from this side.
Because
my lords.
grievance is, my lords, grievance is very, very narrow, my lord. Report at all. What happened?
Committee has given report.
Please.
There is an expert opinion placed before your lordships, which KPTCL was supposed to place in terms of the interim order dated 7/2/2024.
So committee must have identified this committee must have identified the correct answers.
Yes, my lords.
So,
In terms of which there
so
has been
committee
a-
was appointed pursuant to the everybody's consent, or even at least by the order. of the court.
May I make,
If I may, my lord, if
And
I-
normally we'll go by the committee's report, expert committee's report.
what has happened is, my lords, learned single judge has set aside
Segment of candidates can be found.
Take the text. It is
Our
possible.
grievance, was
yes, ma'am.
put to you by Honorable Chief Justice.
Yes, ma'am.
We wanted to know, regardless of the outcome of the appeal, can you find out a segment of a group of candidates who otherwise also remain meritorious?
Correct.
Based upon this one, so that for them, there can be finalization of the appointment itself.
So
It's
you are
already
probably
done,
also
my lord.
short.
That you have to say. But anyway, if everybody is ready.
Not
to-
today,
question-
but
kindly
what
be
we have
heard, my
done now,
lords,
my lord,
because-
is this.
Short question is only this, my lords. Final key answers were published. There were more objections received against the final key answers than the original provisional list. About 900 objections were received. Then, my lords, they referred the matter, KPTC referred the matter to the KER, referred the matter to experts. Experts, my lords, the expert committee gave a unanimous report changing 3 key answers. 3 key answers means in respect of 2 questions, they found the questions themselves to be wrong, capable of more than 1 key answer. So they recommended for 2 questions you give grace marks. Then in respect of 1 question, they found the final key answer published by the KEA is wrong. They revised the key answer. The publication of the revised key answers pertaining to on the basis of expert committee was questioned before the learned single judge. Learned single judge says, my lords, yes, whatever it is for the date for filing objections regarding the provisional list was over, provisional key answers was over. Thereafter, in the guise of entertaining the objections against the provisional merit list, all this could not have been done. My answer is simple, my lords. We had filed against the original provisional key answers also objections, but they were not considered. Then, my lords, when some more people filed the objections against the provisional merit list, then the KEA felt that there is something seriously to be relooked, and accordingly they referred to the KEA. It is an inherent power, my lords, to correct a mistake is an inherent power. And learned single judges, no, after the due date, mistake cannot be corrected. That is the view taken by the learned single judge.
Is correct.
May I seek my lord's indulgence to assist the board in answering what your lordships just now asked the authorities lords were appointing as to whether there would still be some posts available to address this issue. Certainly it will be,
Posts are
there will be
available.
100 seats more available.
97 are available.
As against the appellants who are hardly about. So lords, it can be worked out only after the authorities finalize in 2-3 days, which they say they are at the process. So your lords may have this, by which time it will get crystallized as to whether there are still some vacancies.
100 posts are going to be vacant, my lord.
That's exactly what your lords have noted.
The current,
Order.
Kindly listen, these are the things to be debated in the hearing. Now wait, what we are saying that there might be a candidate, segment of candidate who are of such higher merit that this controversy will not affect them or their merit. If you can identify those candidates, then those candidates will give an appointment outright.
My lord, sir,
Be
may
beneficial,
I have one?
beneficial to the petitioners as well as the authority.
I have another.
The first step which can be over.
I have another thing.
Then we'll work out the things.
I have one submission to make, my lords.
there are people who would be selected either way, without the expert list or nothing. Now, my lords, kindly look at this, my lords. We are persons who came into the select list because of the expert committee report. And according to them, there are vacancies even after this select list of 404. We can also be accommodated, making all appointments subject to outcome of the writ petition. Because as the things, the controversy will remain.
It may be heard.
But my lords would have accommodated the meritorious also.
We are the most happy person.
My lords,
Let us put a complete full stop, my lords. That
on
is what we-
expert, my lords, on expert committee's report, we have been declared as more meritorious. Should we suffer on this saying that last date was over? Law is, my lords, for correction of a mistake, even after appointment, it can be corrected. In MC Bindal's case, Supreme Court out.
Five posts.
Yes,
my lords.
Same post.
Out of 505, my lord, we have now shortlisted only 401. The remaining 97 posts are not being filled up now.
And they
So
are
if
only
they
15.
succeed,
They are only 15.
there are
They are
only
only
15.
48.
15 of them.
Appellants are 15.
So
100 posts are still vacant. They
we'll
can
have
always be
to apply
accommodated.
the roster, my lord, for them also. And if they are selected, there's no difficulty.
The expert committees.
We'll fix it.
Please.
When?
Any
Can we cooperate?
Please.
It will be too long, my
Please.
lords. Many are waiting. 0.25% only because of the blatant error in the questions. We are neither here nor there.
What learned single judge did?
Learned single judge says, my lords,
After the cutoff
after the
date.
last date for objections was over, they could not have entertained.
They go on, my lord.
Rephrased.
Yes, no, two questions were wrong.
Completely
In one
questions
question,
themselves
key
were wrong.
answer
How
was
many
wrong.
marks
How
there
many?
will be?
How many?
Yes, my lords.
So far as 3 questions are concerned, they carry
In
what?
respect of two questions,
Come for each question because 0.5 negative marking is also in place.
Hmm.
So 0.25 negative marking in place, 1 mark per question. So 1.25 for if those answer keys are upheld, then
Even if I have answered correctly also, I would be losing the mark because the key answer is incorrect. This is something completely injustice to me. That's what we would like to.
The maximum marks is 65.
Which date we can fix? If you tell, we'll fix the date. then you
my
cannot
lords,
do that.
next week, any date, my lords. Because
My lord,
my difficulty is, my lords, last week of this month, I will be away, my lords.
We can
Last
try
week.
on 1st April.
First of all,
Please.
First
Please.
of April.
Yes.
It will be also burdensome, but still.
Please.
Lords, the expert committee report may be placed before your lordships as per the previous direction of this honorable court, my lords, on 7/2/24.
Meanwhile, my lord,
Mr. Sondi,
Lordships.
you were saying something with a feeble voice.
My lords, the expert report may be placed before your lordships as directed on 7/2/24, my lords.
Meanwhile, they have to place the expert committee report.
Please, please.
Send over to 1st April at the request of learned advocates for the district.
Lord, one more submission.
Before the next date, the committee, report of the expert committee
Secured by
shall
all
be
the candidates.
placed on record by the concerned respondent.
There are 2 committees, my lord. Let them place
Examination
on the
authority.
committee.
By the Karnataka Examination Authority.
Please. Grateful.
Please.
To file in.
ಇಟ್ಕೊಂಡಿರಪ್ಪ ಸರ್.
Seal cover.
Lord, I was absent, Lord. Sorry, wait, 2 weeks time. Sorry. My lord, appeal filed by the Karnataka Housing Board, my lord. Matter relates to compensation for the Kharab land. Under the consent award acquisition completed in the year 2010, my lords, consent award was signed, wherein the compensation was restricted only to the cultivable land. Regarding the remaining 28 guntas of land which was Kharab, with respect to which no compensation was claimed. Now in the year 2020, a representation has been given stating by the LRs of the erstwhile owner that with interest I am required to pay the compensation amount with respect to the Kharab land, that is the A Kharab land, of A Kharab land. But at that point in time, my lord, I quite concede to the point that if it's A Kharab land, it is not, it's only as per Rule 21 to A, ownership remains with the landlord. But insofar as a consent award, my lord, yes, I compensation. That in the before the writ court, my lords, the learned single judge, contentions were indeed taken up by relying on certain circulars, which I cannot press those. But the other point, my lord, relates to the consent award, my lords. In the consent award, the the landowner, the LRs have filed the writ petition. He has restricted his claim for compensation only with respect to the cultivable land. He says, if I may be permitted to read the relevant portion, my lords. My lords will find this at page number page number 178. It's in the vernacular language. Translation is also provided, but to understand the true purport, my lords may refer to page 179. My lords have the affidavit, page number 2. May I read the first paragraph, my lord? Yes, admittedly, I've taken that land. But while consenting, he has said, I am only entitled to get for 7 acres, 16 guntas. The first line. And on that basis, my lords, the awards are also passed. 2 separate awards for 2 parcels of land. There is one portion, there is, my lords, one portion of B Kharab is land, is there in the land. But for that, there is no, that's a government land. That's a government land. The only issue that remains is as per the affidavit, and thereafter, my lord, even in the consent award, the same statements are made to the effect that he has claimed only for 7 acres, 16 guntas and not for the remaining 28 guntas of A Kharab land. Now, my lords, after 10 years, the LRs have realized, after even if this realization, yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, my lord. Yes. My lords, because the only representation that was made thereafter, after the consent award was passed, my lord, was 10 years later, my lord. 10 years. After, only at that point in time did they, in fact, re-agitate this issue. Yes, my lord, that is also placed on record. Two documents, document number 1 and 2. Even with respect to position, they have not agitated that you are not entitled to take position. For the longest time, 2008 is when the acquisitions were completed. Yes, my lord, that portion may have to be considered because there is an IF for continuation of delay notice. There is some delay on my part.
My lord, I take notice for respondent number 3. 4. 5, my lord. No, you've not numbered. Yes, 5.
May I be permitted to serve the counsel who represented them in the writ court? Yes, my lord. Yes.
I appeal for the respondent. Appellate. Special peculiar case minutes for absent of 107 days for ill health. He is thrown out of employment minutes. Even before the learned single judge also we have tried to settle the matter. But since it's a public sector, they are not in a position to take a decision. It's a 107 days of absenteeism.
Lord, the issue is.
One more. Court has also not granted any back wages or anything, minutes, only restatement of the continuity of services.
Lord, the respondent was working as a design engineer. Now, my lord, we had incurred a lot of expenditure to train him and then take him. And after confirmation, my lord, he had also agreed that he will work for a minimum period of 2 years. Then, my lord, he takes earned leave and goes to his native place. And from there, my lord, he seeks extension of leave on medical grounds. Then, my lord, he was asked to come and report to the high-tech hospital that we have, my lord, in Bangalore to check whether he requires such a rest for 3 months. He has to come from Gaya. Then, my lord, not only that, after that, we have written 3 or 4 letters. Then he produces a medical certificate. Now, my lord, that we checked with the doctor who issued a medical certificate. Now, my lord, he says, I did not advise him rest for 3 months. He insisted that I should give such a certificate, and therefore I gave him such certificate. That is also, and he does not even appear in the inquiry. This is the conduct, my lord. He is not a workman, my lord. He is an engineer. He is an officer. Yes, my lord. My lord, kindly see page 32. My lord, Leonard Singh judge holds that merely because he has sought for extension on medical grounds and produces some medical certificate, it ought to be treated as having been granted. No, my lord.
He has taken treatment in HIL hospital also. No. Yes.
Lord, it's not merely 107 days. No, my lord, continuously he remained absent until the punishment was given because he was not suspended. He could have come and then reported at any time. Even that he did not do. He was an engineer, my lord, design engineer.
Once the charge sheet is issued, they will not allow him to enter the factory.
He never made effort. And my lord, dismissal was there. It was ultimately in appeal reduced to removal. Yes, my lord.
Yes, my lord. In the appeal, it was reduced to removal, which does not disqualify him for future employment. Yes. Sorry, my lord. No, my lord, the order of punishment is 15th May 2017. Will be, my lord, one minute. Check my free.
Because in all public sector, the practice is.
From 22/9/2016.
Once the charge sheet is issued, the security will not allow them to. That's good. That's it. That's there, man. Yes.
No. Check my 2016 to order of punishment. 15/5/17. Yes, yes.
That will not benefit me, my lord, because I am already aged about 35 years, my lord. 36 years. 36 years, my lord. There is no financial burden to the employer, my lord. No financial burden. He will work and gain his livelihood, my lord. Because before he leaves to his native, he has taken treatment in the HL hospital itself, my lord, for this back pain, my lord. Thereafter, he went to his native place. There it was. Because, my lord, he sends the telegrams and other things because he is advised not to travel to the Bangalore, my lord, from back.
Yes.
That's true.
Yes.
Bed rest is not. That's their contention, my lord. But
The doctor sent a report, my lord, and that a copy of that, my lord, he did not appear in the inquiry. We sent the inquiry proceedings and then gave him time to come and appear again.
But anyhow, my lord,
Total absence is around 8 months, my lord.
Again, get his livelihood, my lord. At this age, my lord, he may not get any employment, my lord. That's the problem. He is a qualified engineer.
Total absence is around 8 months. 8 months. No, my lord.
No.
That was prior to.
Much.
In fact, Leonard Single Judge has failed to notice that.
We are challenged that order only, appeal order only, my lord.
Yes.
After exhausting the appeal provision only, I approached this honorable court, my lord. Anyhow, my lord, there is no financial. Yes, yes, ma'am.
Yes.
2 minutes. My lord. Just 2 minutes. At that age, it is not possible for him to get the employment, my lord. He has worked here for almost 5 years. Till even today he's out of employment. He's not gainfully employed, my lord. Not employed at all, my lord. Now, not only gainful, not employed at all, my lord. He's waiting for this. My lord, actually, exactly to say 107 days, my lord. Absenteeism.
Yes.
Just 2 minutes. I am not disputing that fact, my lord. But anyhow, since there is no financial burden,
yes, my lord. Annexure B, my lord, page 62, my lord. Page 64 is the operative portion of the order in the appeal, my lord. Para 7. Accordingly, I, as appellate authority, hereby reduce the punishment imposed upon you by the order dated 15/5/27 to removal from service, which shall not be a disqualification for future employment under government.
Let's, one request, my lords.
Pradeep Savkar.
A.B. Narayan Swamy. My lords, before that, one request, my lords. Sorry, my lords. We will, matter may be posted before mediation center, my lords. We will request, we will try to mediation. Or if there is any possibility of settlement.
Lord, that is not possible, my lord. We tried that, it has not been possible.
Because he's
Board
liable,
is,
my lords.
we'll have to take up board of approval, that may not be
Otherwise,
possible.
I would not trouble my lords. Because there is no financial burden, my lords.
We did that exercise, my lord, it is not possible. Otherwise, we would have settled it during the course of the
Because they are the
proceedings.
model employers, my lords. I am with your ranch, my lords. Because his livelihood, that's why, my lords. That's true, my lords, that may not benefited me, my lords, that's the problem. But that's true, my lords, I am not disputing those facts. But those, in any public sector, my lords, once the charge sheet is issued, they will not allow. I have not tried, that's correct, my lords. Your lordship is correctly on. But anyhow, my lords, let him work and earn his livelihood, my lords. That's all, my lords. No financial burden, my lords. Otherwise, I would not trouble my lords because my lords know me. That's true, my lords.
My lord, but the officer is here, my lord. That, my lord, your lordship may consider, my lord. Well, the problem is this, my lord. My lord, he was trained for a particular job. Now, my lord, if he does not come for 8 months, my lord, I suffer there. My lord, I design the aircrafts for the defense. That is the problem, my lord. Engineer design, my lord. Sorry, my lord. Not fake, my lord. The doctor says that he had not advised, it did not require rest for 3 months. But then that was given at his request. Because he had only given medicines. He had not advised bed rest.
Not required bed rest.
Yes, that was what was.
In Bangalore also he has taken treatment, my lords. That was observed by the learned single. In the same hospital, HL hospital, he was treated for this back pain, my lords.
Yes. Not page 62, annexure B, 19/2017.
There are 5 of the learned single judges are. Yeah. Several representation for extension of leave. For several representation for extension of leave.
Yes, sir. Totally 8 months. my lord.
That may not be taken into consideration, my lord, because it's not willful, my lord. Once the charge sheet is sure, the relationship pattern on the record, at least in a livelihood.
Yes.
Yes. At page 184, man, start from 184.
Page 126 of the report, my lord, your lordship may kindly see on top. Yes, my lord. No further details about treatment being availed after 15 to 17 has been furnished. As could be seen from the CSO has been absenting continuously from 20 to 9 under the pretext of back problem. Chitranjan Sharma, Dr. Chitranjan, who had issued a certificate, has himself confirmed that the certificate was issued at the request of CSO. And he did not turn up for any follow-up treatment or physiotherapy. It appears that after failing to get the further certificate from Dr. Chitranjan Sharma, for the reasons explained earlier, CSO has approached a new doctor. The HL doctor has also certified that the problem being mentioned by CSO does not warrant 5 months of bed rest. Page 126, my lord. That's the report of the inquiry. Charge sheeted officer. 14/12/2016, I think. Page 63, my lord. Yes. Nice. Obliged.
I appear for appellant. Appellant is fourth respondent before the learned single judge. Legal hire of the grantee, my lords. The assistant commissioner. The assistant commissioner and deputy commissioner, my lords, held the section 4 and 5 of the act applies and ordered for resumption of the land. Commissioner is challenging the order of the learned single judge at page 13, my lords, dated 29/11/2018.
Likanti.
Likanti.
So we'll issue notice received, notice to the
Please.
respondents.
AGA.
My lord, I take notice for respondents 1, 2, 3.
2, 3. AGA.
Government additional government advocate accepts the notice on behalf of respondent 1, 2, 3.
Yes,
So to be listed with those matters
yes.
Please.
Yes, my lord. 2/10 of 23.
when it is.
2nd of April.
So returnable on 2nd of April. The parties are directed to maintain status.
Please.
By of aid dream, it is directed that the parties are directed to maintain status quo.
May I apologize.
Subject matter, it is land.
No, my lords. There is a delay, my lords, therefore I don't press for it.
Acha, delay. So only notice.
Please, my lord.
But on that day after condonation delay, you can remind us. Because in all
Yes,
other.
yes, my
you
lords. I will remind.
will not be class bites.
Please.
So fair. Open.
Is very,
yes.
Number 49.
Appearing for the petitioner lordship, this petition filed seeking mandamus to consider the application to renew the quarry license, your lordship.
Filed objection. The lapse please.
Last under 2016, 2016.
2009 application.
2009 application.
9, quarry lease was granted, expired on 24/8/2014.
It was granted on
25/8/2009 for a period of 5 years. Expired on 24/8/2014.
24 June.
8
August 2014.
Renewal application was filed on 20th June 2018. After lapse of 2 years, 2 months. As per rule 21(2), Lord,
Within
it
what
ought to
period?
have filed 90 days prior to the expiry of the lease.
Rule
21(2).
21(2).
Yes.
Of 94 rules.
1994. Not this renewal application was rejected on 10/7/2018. There was arrears also, blood, to the extent of 1,26,260. Revision was filed against the rejection order on 23/9/2022, which is also after lapse of
around 4 years.
Rejected on 23.
Rejected on 10th July 2018. Revision was filed on 23rd September 2022. And revision was dismissed on 9/12/2022. On the very same ground that the renewal application was not filed with it.
Your Lordship.
And
the
it is
only
covered
reason-
by the judgment of this honorable court, which I have produced along with the statement of objections as per annexure R1.
So he wants to take the benefit of that amendment? No.
Amendment is not applicable.
Your Lordship, only reason that at the time of expired the lease, the petitioner's father was bedridden. Then he was admitted in KMC Hospital, Mangalore. He was busy in taking care of his father, Your Lordship. After the death of the father, he approached the concerned authority to renew the license of the quarry, Your Lordship.
Whether
Now he
medical
is ready
ground is
to pay the
recognized?
royalty, the arrears of royalty, he is ready. The only kindly allow the humanitarian grounds may be applicable.
We are dealing with stone, not human beings, carrying matter.
Is the daily income based on, it depends on this quarry business, Your Lordship. Now he is.
The challenge in this writ petition is.
Jurisdiction is very narrow as far as.
The challenge in this writ petition is to the denial of request for renewal of the mining lease. First, the authorities rejected the request for renewal, relying upon the provisions of Rule 21(2) of 1994 rules, which prescribe that renewal can be sought for 90 days prior to the expiry of the lease. First, matter was taken in revision under Rule 54, and revision also came to be rejected.
53.
53. Revision also came to be rejected. First. Next, learned counsel for the petitioner vehemently argues that the request for renewal could not be made. Petitioner's father was admitted to hospital in Mangalore, and the petitioner, being the son, was looking after him. And therefore, on humanitarian ground, the prescription of limitation could not have been acted upon. First. Next paragraph. After service of notice, the respondent authorities, having entered appearance through the learned EGA, have filed the statement of objections resisting the writ petition, contending that the prescription under Rule 21(2) of limitation period of 90 days is held to be mandatory by a coordinate bench of this court in several decisions, and therefore there is no provision for condonation of the delay in matters like this. First, he also contends that the rejection was again justified because the petitioner remained in arrears of rupees
1,26,260.
or 26,460 as well. 260 as well. First, he further contends that the revision also having been negative on the grounds on which the original request for renewal was denied, there is absolutely no reason for interference of this court. First, next, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned government advocate, who heavily banks upon the provisions of Rule 21(2), which prescribes mandatorily a period of 90 days prior to expiry of the lease for seeking its renewal. First, when there is no provision for condonation of delay, court cannot condone the delay in as much reframing the rule obtaining in the field. First, this apart, the conduct of the petitioner, even otherwise does not merit indulgence at the hands of this court because of the conduct, because he retained the amount belonging to the state with no justification whatsoever. First, petitioner's counsel submission that he is now ready and willing to pay makes no difference to the merits of the case. And it will be highly appreciated if he remits that said amount to the exchequer, which is due to the state first. In the above circumstances, the petition being devoid of merits is liable to be and accordingly dismissed.
Number 50, KP Bhuvan.
Against the interim order.
Appear for complaint. Willfully disobedience order passed by the single judge, my lord.
You complain it to the learned single judge.
21/11/2023 order has been passed, my lord. Stay the DC order. Immediately approached and furnished along with the representation on 23/11. The respondent has been changed my revenue entries on 6/12.
Learned counsel for the respective parties. From this contempt petition is not entertained only on the ground that the order sought to be complied with is only an interim order, whereby the notice was issued to the respondent and till the next date of hearing, stay of the order dated 15/9/23 came to be granted by learned single judge. Full stop. The matter, the dispute is at large before learned single judge on its merits. Full stop. This order does not decide, the interim order does not decide rights of any of the parties finally. Therefore, the order which is of interim nature is not liable to be dealt with in the
My lord. contempt jurisdiction. My lord, my name has been changed, my lord, in RTC column.
The petitioner is the complainant to be open for the complainant to approach learned single judge and work out his remedies and rights in the parent proceedings without expressing any opinion on merits any further. The contempt is dismissed.
Number 51, Mr. Manjunath H.
And we have filed complaints. No?
Complaining.
There is no interference with the
What was the direction?
function. Page number 3, Mlad, I have extracted.
Page 15.
Yes.
Consider representation.
Not consider, mandamus issued to the consider representation, that's one. No? Then respondents are at liberty to take legal
action in the event the activities of the recreational society are found unlawful. While doing so, they shall bear in mind the order passed in so and so.
We have issued an endorsement to that.
Saying
Annexure R7, page number 28/2/2020. Page number 37. In the complaints, it is also stated that there are other cases registered against the complainant also. As per annexure R1 and R2.
where is the violation, brother? Kindly come to page 36 of objection, the complaints report.
Lords, my submission is that, my lords, there are two things, my lords. One, they initiate proceedings against the persons who are engaging in illegal activity in my premises.
Yeah.
And second thing is, my lords, they barge into my premises without any lawful authority, without any court order, and they put themselves something and they create a case. My lords, I'm only concerned about the issue, the second one, my lord. Here, what has happened? Earlier instance, they raided my premises, they reached an FIR. Subsequently, they start coming every day on a daily basis for the reasons best known to them and demanding the closure of my premises. My lords, what has happened is, in my premises, all the members have been issued ID cards. We have put CCTV cameras and I have complied with all the basic requisite conditions as prescribed by the Honorable Court, my lord. And to invoke 7980, what ingredients required, they are not obeying it. My only limited prayer is that before my lordships is that they can come and examine, they can investigate, it's up to their purview. Only thing is that every day they come to my premises only on the pretext that I came to High Court and they harass me on the one pretext or the other, my lords. That is my grievance. Otherwise, there is no point in coming to in the contempt proceedings. My lord.
Come to page 14. E, clause E. Page 14, clause E.
Please.
This is the standard format which has been printed by the learned single judge.
Please.
Permits the police. Where does it say? Police should come only on full moon day. It is periodically, whenever they want. It's a policing activity. What all you will do there, they want to see. It's a public space now.
I bow down to that, my lords. I bow down to that. My only repeated submission before my lordship is they can take a lawful action against me. It's open at any point of time. But coming on that pretext to into my premises, threatening each and everyone on orally, my lords. Orally, they do it orally. They never come with a search warrant or something. They come orally inside my premises. Because of that, people are not coming into my premises, and even I'm not able to pay the rent also, my lords. That is my grievance. So, my lords, leaving that one request, if I may, my lord. Now, what the authorities are saying, my lord, election munde barta ide. For that reason, we are not allowing you to function until. My lord, is my lawful right
Where is
to.
that?
My lords, they say it orally. That's the whole point, my lords. My pleadings also have.
Suppose if we pass the oral order, you should have insisted upon. Give in writing. Bring something. We may consider.
My lords, I did it 100 times, but they are not listening. That's why I'm in the contempt, my lord. One request.
If we observe again, their hands will be strengthened. Instead, you withdraw this. Work out your remedy. Otherwise, if we say now, which we are inclined to say now, that we are not interfering in this matter, because the police vigil is permitted under clause E.
My lords, now the copy has been served, my lords. I may be permitted to make a submission. A week's time may be granted.
Not
so
now,
that my lords, just now I have been.
But you argued that.
My lords,
That's the only thing he has said.
My lords,
If you had said, now only I have received, give us time, we would have granted you.
My lords,
Having argued and not knowing the mind of the court, you know.
My lords, I have been granted with the hold to lawful activity, trade activity by
You
the
do that.
Constitution of India. My lords.
Conduct
They are
all
curtailing it. My lords, that's only.
Conduct all lawful activity. They will not do anything.
They are threatening, my lords, on a daily basis. What I'm suffering is that, my lords, because of that, I'm here before my lordships seeking for the.
Gambling inside the premises.
No gambling at all, my lords. No gambling at all.
Last में kindly period last paragraph.
On request, if my lordships, I may, my lord, kindly, I make my submission and the next date of hearing, my lords, kindly a time may be given. So, because I have been served with a copy of the. Please. Compliance affidavit has been furnished to me, my lords. I will make my.
Granting time up to
Please.
19th of March. 19th March.
Yes. Great.
Can we dictate the order today?
No.
Month, but no further time.
Please.
Don't run away.
Definitely, my lords.
Number 52, Mr. K. and Manjunath, 14%.
Sir, this is a contempt petition. I will brief, please refer page number 1, sir, synopsis. 1 minute, I will brief. Page number 1, brief facts. The complaint had filed writ petition number 24288 on 31/10/2023 regarding a rectification of a glaring error in the Kaveri Tribunal verdict at clause 9. It was appreciated by this honorable court in its order dated 17/2023.
Page 16.
Yes, no contempt.
Yes.
But the AGA and CGC opposed the PIL not on merit, but under Interstate Water Dispute Act 1956, stating that this court did not have power to rectify the glaring error under Article 227.
Mr. Party in person, what is your problem?
Sir, I am telling you, I am come to that.
Come
In the
to-
same, sir, it is there. Just
Because if you don't have any problem, we have problem.
no, I will come to that, sir. Yeah, their point was in view of the rule 11 of the Interstate Water Dispute Act 1956, as per which only Kaveri Water Dispute Tribunal could rectify the error, which is functioning since decades. But they have made a false statement before this honorable court, suppressing Rule 12 of the Interstate Water Dispute Act 1956, as per which the Kaveri Water Dispute Tribunal was dissolved by a gazette notification dated 16/7/2018, sir. Sir, kindly annex A4, sir. Page 20. Annex A4. It is the government G1 notification. The Kaveri Tribunal has been dissolved by notification dated 3465, dated 16/2018. So they have made a false statement, and by that, the court which was about to issue a favorable order, you are deprived of that. And the PIL is about Kaveri River Water Dispute, sir. The entire state is.
That is all.
Sir?
That is all. This is contempt petition.
False statement they have made. They have made a false statement that Kaveri Tribunal is still working, but it is not working since 2018. That is our
For so-called
permissions.
for so-called false statement, you go before same learned single judge. There is nothing to be complied with here. Your petition is dismissed, isn't it?
No, it is not dismissed.
Yes.
No, sir, please. Page number Annex A1, High Court order.
We decline indulgence in the petition.
Yeah, that is because, sir, they have admitted the arguable defect. They have admitted the defect. They have not argued on merit. They have not argued on merit, sir.
You seek recall of that order.
Yes.
You seek recall of that order of the division bench, saying that what learned Advocate General said was false. Now truth has come out. It's a ground for recall.
So you will come here only, sir. The recall order.
Recall in the before the same judge, same learned.
Sir, the case was heard by this court only.
Here it can't.
It's contempt.
Yes, sir. Sir, that respondent number 2 is passing highly obnoxious, irrelevant orders. That is why we are Karnataka state is suffering, sir. We are not following any clause in the tribunal. This one. Entire Karnataka is suffering because of that. There is a defect in the manufacturing defect in the tribunal verdict, and they have admitted it. They are not ready to rectify. That is because of that Karnataka is suffering. And it has become a headache for Karnataka state government also every year. Why they cannot publish the Karnataka entitled monthly share of water, sir? They have not published Karnataka figures.
Jurisdiction of this court under the Contempt of Court Act 1971 has been invoked by the complainant party in person in respect of order dated 17th November 2023, passed by the division bench of this court. Paragraph in that petition, prayer was made by the petitioner in respect of to direct the respondents to publish certain missing Karnataka column in the Kaveri Tribunal award. Full stop. Learned single judge observed that since the Kaveri water dispute tribunal has been functioning since decades, any such direction given, any direction which is sought for could not be given to the petitioner. Resultantly, holding that there was an impermissibility in law for judicial intervention in the matters of the kind put forth before the court, the petition was not entertained and the indulgence was declined, meaning thereby the petition was dismissed. Full stop. This court is at pains to understand that how the contempt jurisdiction could be invoked in respect of the order in petition which was dismissed. Therefore, this contempt application is thoroughly misconceived and liable to be dismissed with cost of rupees. What cost?
That PIL, sir. I have made PIL.
With cost, however,
Sir.
taking a lenient view since the complainant is part in person, without imposing cost, the application is dismissed.
Thanks.
So about 53, Shyam Shuprakash.
My lord, complaint is appellant in regular first appeal before this in a division bench. The respondent also entered into caveat. After hearing the matter, the Honorable Court passed the interim order, page number 26, my lord. At Annexure C. I number 1 of 22 is filed for temporary injunction and I number 2 for stay of judgment decree. By interim order, it is directed that parties shall maintain status quo regarding possession and revenue entries. This is the order after hearing the caveator. Then again the caveator again he moved the matter.
The order dated 21/9/22 passed by a single judge in the proceedings of regular first appeal and the interim applications filed therein is brought under contempt jurisdiction. Evidently, the order dated 21/9/22 is an interim order whereby the status quo is ordered. Full stop. The interim order does not determine rights of the parties. Finally, full stop. The subject matter dispute is at large in the parent proceedings. There is no trappings of finality in this order.
My submission is after hearing the caveator.
In the aforesaid view, against the interim order, the court is not inclined to entertain the application and exercise the contempt jurisdiction. Accordingly, this contempt application is dismissed.
54.
It will be open for the complainant to work out his rights and remedies in the pending proceedings.
54.
For appellants. But the appellants,
Delay is condoned.
please,
Condoned.
my lords, notice has to go, my lords.
Notice. Notice to the respondents.
Published.
Written
Lord, I
about-
take notice for respondents 1 to 3.
returnable on 10th April.
Published.
Learned additional government advocate waives accepts notice on behalf of 1 to 3.
Number 55.
55, my lord, I'm pointing out, there is another writ appeal, but there were 2 writ petitions. But by common order, my lord, both the writ petitions has been dismissed. Another writ appeal has also been filed, my lord. Let it be posted, my lord, together. So that writ appeal number 85 of 24.
What about delay? Everybody is appearing?
My lord, maybe
So we'll
I am not a party in that writ appeal, though it's right. My learned friend is right, my lord, when he says that by a common order, 2 writ petitions were
It is
disposed.
arising from the same order.
Yes, that's
Same-
true, that is
same
true.
order.
Today will issue notice in the delay application.
Notice has to go to other respondents.
There is
There
no,
is delay.
there is some, we will be able to, that the other matter is also posted.
We'll put it together on the next.
Notice,
Very
Notice
well.
returnable on heard learned senior documents, so assisted by learned. There should be notice. to the
My lord, I take
respondents.
notice for respondents 1 and 2.
1 and 2.
Returnable on,
Others, notice.
No, my lord,
Only
only
two.
1 and 2.
returnable on 15th of April. Learned additional government advocate accepts notice on behalf of respondent 1 and 2.
You are for respond 3.
For respond number 4.
4.
4.
How many
Learned-
respondents are there?
But there are a few other respondents.
So you are also accepting.
I am only for now format, except for 4.
Learned advocate, so and so accepts notice for respondent 4. Rest of the respondents will be served. Learned advocate, so and so of the respondent 4 stated that writ appeal number so and so arising out of the very judgment and order of learned single judge is going to be listed on which date?
Murder, writ appeal number 85 of 24.
85.
Notice is issued or yet to be?
Not, it is not come, I think it's not.
It
been
has
listed.
not, my lord, office objections is the stage of.
They
office.
also filed and the same is lying in office objection. Full stop. If the office objection is removed on or before 15th of April, comma, both shall be listed today.
It will be listed for admission. Very well.
There's a delay, my lord, I can't ask for stay.
Number 56. G.R. Mohan.
For the complaint to watch. This case, your lordship, matter pertain to the pressure of lake restoration. Annexure D, your lordship, is the order passed by the, on IA number 1 of 23, page 38, your lordship. In that, several directions were issued to preserve that Malatali lake. The lordship will find at ink page 55, your lordship. Before that, paragraph 15, though the order passed by this court on so and so does not prohibit construction, it does not mean the authority cannot grant permission to construct a temporary idol so and so, as rightly submitted by the senior counsel so and so. In the light of the discussion made above, we passed the following. The authority shall ensure that there shall not be any temporary or permanent construction or commercial or recreation industrial activity, and there shall not be any pollution or conducting of any act which is determined directly indirectly to the tank area. The authorities also shall not permit any individual or so group or any political party to use the tank area for recreation or celebration, and so also ensure protection of the tank. This is important. Clause 3, as admitted by both the parties, since the total area of the tank is 71.18 acres, except the dispute with respect to 3 acres as stated, which is pending before this water spread area of 42 acres, which is now increased to 44 acres, should not be allowed to decrease. And the authority shall ensure that no individual group or political shall be allowed to construct any permanent structure within the area so and so, so and so. The authority shall ensure that Kalyani, then your lordship may kindly see,
The authority shall not grant permission put up any page number 57. With the above direction, applicable numbers also dispose of the said directions are temporary measures which are subject to result of the. We hope that trust that the respondent BBMP, including government, will not create unnecessary litigation before this court and ensure compliance of provisions of case. By virtue of that, Your Lordship, Annexure E is the email which I sent along with the photograph and representation, bring it to notice of the authority. E2, Your Lordship, is the photograph, page number 62, Your Lordship. E2, E3, E4, now they are constructing a road, Your Lordship, which is contrary to the section 12 of the Karnataka Tank Conservation Act. Then another bund is also formed now, 80 feet road, Your Lordship, which connect to an apartment the other side in the lake bed, Your Lordship. The lake, Your Lordship, may kindly see, it has been reduced now, lake area. You know, they have given an undertaking, Your Lordship, the affidavit also filed by the BBMP chief engineer at page 36, Your Lordship, that we will put fence on all the sites, but fence also been broken now. And also Your Lordship, you can see the sewage lines also been put up inside. It is also contrary to section 12 of the Act.
Which direction is violated?
The direction, Your Lordship, is that it should not pollute either pollute the water either in the lake area or in the Kalyani. It should not pollute, that's what they say, pollution. And also they reduce the water area. Now by virtue of this construction of roads, which is now Annexure E2 and other thing, the lake area and also the lake bed is reduced, Your Lordship. Because they have to maintain the 42 acres. And also water spread area about 40, which is now increased to 44 acres. Now the actual virtually there is no water at all, only a small portion of is there because the road is constructed now inside the lake. Your Lordship, you can see the fence, Annexure E3. There is a fence on the left side. This road is being constructed in between that, which leads to the other side of the area, that is east side of the lake. Another is south eastern side to connect south north areas also. Which is not, then Your Lordship, may kindly, sewers are being constructed inside the lake area, which is prohibited in section 12 of the Act.
That roads are laid in the lake area.
Yes.
These roads are laid.
Yes.
In the lake,
Yes,
bed, on the lake bed.
Lake bed. That's what the photograph Your Lordship. The walkway is there. If you annex it, if Your Lordship look at the walkway is there, path for people to walk. Then by that side, this road is being constructed.
But this lake is in the residential society?
Yes.
In the middle of the residential?
The other side is the residential to connect that.
Connecting.
That's what they are planning.
Connecting the
In spite of
society.
yes.
Residences.
Yes, Your Lordship. Which is not permissible. And also the sewer lines cannot be constructed inside the lake bed. Your Lordship, may kindly see both the side sewer lines are there. Which is under.
Who will appear?
The BBMP commissioner.
Heard learned advocate Mr. G.R. Mohan.
Yes, Lord.
For the complainant, notice to the respondent returnable on 3rd April.
Yes.
3rd April. On the next date, the accused shall file his response.
J. James, party in person.
My lord, I appear for the respondent number 1 to 3. University, my lord. Pray for a 2 weeks time to file the statement of objections. Pray for 2 weeks time to file the statement of objections.
You appear for respondents?
Please, my lords.
57.
So to be common. IA number 1 of 24. The prayer is to condone the delay of 112 days, which has taken place in filing the writ appeal. Upon consideration of the arguments made in the supporting affidavit, it could be said that the sufficient cause is made out to condone the delay to the extent of 100. Delay is condoned. Application is allowed.
Number 58. Shivraju MK.
This learned single judge has passed an order, annexure, page 8, my lord. In operative portion, page number 12, my lord. Third respondent is direct to register the kata subject to verification with regard to genuineness of the otherwise of Akkupatra produced on annexure A by the petitioner within a period of 2 months from the date of this order.
Our learned advocate, Mr. Shivraju MK.
Yes.
Notice returnable on 15th April.
Number 59. Abhinav Ramanandiye.
The complainant, my lord, was the petitioner, the writ petition. Writ petition was filed seeking a direction against the accused herein to enter the name of the complainant in the revenue records. Accordingly, my lord, the writ petition came to be disposed. My lord, page number 14 is the order where my lord passed an order directing the accused to
So notice.
enter the
Notice.
I accept for R4.
R4.
Learned government advocate, Mr. Mahendra accepts notice on behalf of court. Same returnable date, 15th.
Published.
Number 60. To PH Virupaksha.
Appear for the complainants, my lord. Lord, the order of the Honorable Single Judge, my lord, says that annexure C, my lord. Page 38, my lord, the petitioner's complainants, my lord, had sought, my lords, for a direction, my lords, to the Deputy Commissioner, my lords, to consider their application, my lords,
Dwelling houses.
it's
They have not responded.
my lords, they have not.
Same order.
For R2, R2.
For art. At same dates.
61 urgent, seal number 62.
My lord, I am appearing for
VV
appellant. In this,
Sidramaya.
appearing for appellant in this case, my lord. My lord, the appellant was working as a revenue assistant in the respondent company. The appellant was working as a revenue assistant in the respondent company.
Please not. Video.
VV Sidramaya.
Appearing for appellant, my lord. My lord, appellant was working as a revenue assistant. Learned single judge has dismissed the writ petition on the ground of delay, my lord.
What happened to that criminal cases?
My lord, criminal cases were still pending, my lord. It was not
Still
decided.
pending.
It was not decided.
What
And
are
she has taken a treatment for us mental illness.
those cases, offenses?
My lord, offenses is, my lord,
My lord, the police inspector has misbehaved with the appellant. My lord, he has quarreled with the police inspector is the allegation made against the petitioner. My lord. Her mental illness and mental conditions has not taken into consideration. My lord, it was dismissed on the ground of delay. Final report is at page number 65. My lord, annexure F. Page number 65, my lord, there was a call from the police inspector to the appellant. There was something fishy in this, my lord, that needs to be considered. So she has questioned the same in the police station. Why you have called me is the allegation made against the police inspector.
Anybody appears? First time?
BL Sanjeev.
First. Yes. So, Mr. Siddha Ramaya, we are not inclined.
Yes, please.
Challenge in this writ appeal. By the appellant original petition. Is addressed to order dated 21st June 2023, passed by a single judge, dismissing the writ petition. Paragraph. What was prayed in the writ petition by the petitioner was to set aside order dated 2/11/17, passed by this one number 3. Yes, the superintendent engineer into electricity, Bangalore Electricity Supply Company Limited. Whereby the petitioner came to be dismissed from service. The petitioner was on contractual, was in service on contractual basis. The termination of his services was not dismissed, terminated. The termination of services was effected on the ground that the petitioner violated the terms and conditions of the appointment order. Paragraph. The case
No statement.
piece of the hair of it. So, therefore, simply say that without anything. If it is so simply say that. Then what is this? Makes that you are aware.
It appears from the record that the prayer of the petitioner to set aside the termination and to reinstate her was negatived by a single judge. Taking into account the relevant aspects. First was that the petitioner was appointed on contractual basis. Secondly, there was a registration of FIR being crime register number 161 of 2017, as well as another case number 581 of 17 was registered before the Court of Civil Judge Koratagre, GERE. The prayer. The weighty aspect was that the termination order was passed on 2/11/17. The petitioner challenged the said order after the owning gap of 5 years by filing petition in the year 2022. Full stop. The delay of 5 years in approaching the court has not been explained, much less satisfactorily. Litigant who sit tights for 5 years without any good cause would lose right to relief. Full stop. On the ground of delay in seeking relief, the only ground of delay of 5 years in seeking relief, the petitioner was not entitled to get was not entitled to be, the petition was not entitled to be, petition was not required to be entertained. A single judge was eminently justified in dismissing the petition and in not granting relief to the petitioner. Paragraph.
My lord, one
Appellate
clarification.
jurisdiction by this court is not required to be.
My lord, one clarification. My
exercised.
lord.
The appeal is dismissed.
That's one clarification. My lord.
Yes.
See, CC 581 of 2017 is a continuation of crime number 161 of 2017. After filing of charge sheet, criminal cases registered. That's only clarification.
After FIR, after filing of first infantry report, charge sheet was also filed and the criminal case was registered.
Please.
Case number 63, Devi Prasad Shetty.
63, my lord. Senior counsel is, my lord, on his legs. I seek for, my lord, senior counsel is on his legs, my lord, in total 13. I seek for a passover, my lord. Oh, my lord, is now.
You are also senior counsel.
No.
All like passover will not be possible. Some other day.
No, election matter, my lord. Tomorrow is the my election is set aside. Lord, the date is fixed for tomorrow for the co-option. Therefore, some
Objection to what?
For my post of directorship, my lord, I was elected as a director for the Mandya Milk Union.
It is scheduled tomorrow.
For the now, my lord, since my election is set aside, my lord, now they have fixed a date for a co-option, my lord, tomorrow. He is on his legs, my lord, total 13. I had the benefit of the interim order, my lord.
Tomorrow.
I'll take a chance today, my lord, otherwise tomorrow.
It's by nomination now, because of removal.
Yeah, because of removal, because of, for the vacant post, my lord, the co-option.
The benefit of interim order
I had the
at
benefit,
in the writ
all
petition.
through, my lord, in the writ petition.
It was operating.
Yes, my lord.
What was that order? Not to fill up the, not to nominate.
No, the order of the Karnataka Appellate Tribunal was stayed in the before the learned single judge.
Stay was there.
Yes, stay was my.
So you did not get it extended by learned single judge.
No, my lord, there.
Why? So it was the post of what? Register, director.
A director, post of director.
In cooperative society.
In the, madam, yes, my lord. In the federal society, Mandya Milk Union.
So what is the period, what is the term? 3 years?
It's for 5 years, my lord.
5 years.
5 years.
So what is the remainder period left?
Another 3 months.
3 months only.
No, it will come to end in the month of September, September 2024.
You know the concept of rounding off?
So next.
Lordship, I have.
Round of.
Only 3 months.
Anyway, this is in lighter way, but what shall we do?
Any of election dispute is raised in immediately after election. We spent much of the time
Is there
in.
any provision in that act regarding election petition?
Yes, election petition was filed. It was allowed, it was dismissed.
No, election.
Then appellate tribunal, we approached in appeal. Appeal came to be allowed and election was set aside.
Election petition only was decided. Yes.
That order.
Confirmed it.
Yes.
No, dispute was dismissed. Their dispute was dismissed. They challenged against the dismissal order, my lord, appeal was preferred before the
Appeal was allowed.
Appeal was allowed and writ petition, my lord, I preferred the writ petition in which interim order was there.
That was
But that was now, the appellate order was confirmed in the, by the learned single judge.
Both learned single judge and appellate tribunal holds they are not eligible to contest. Nomination is improperly accepted and it is.
Senior counsel.
Not, he is on his legs in total number 13, my lord. Mr. Jayakumar Patil. Tomorrow.
Very.
Please.
Mr. Council will take up at 11,
Please, please,
since you are in hurry.
please, my lord.
If you are not in hurry.
No,
then-
I'm in a hurry, my lord. I'll be here.
14, 11 years.
Number 64, Mr. K.S. Naresh Santosh.
My lord, I am appearing for petitioner in this
Number
matter, my lord.
64,
My lord, I am appearing for petitioner in this matter, my lord. My lord, it's a public interest litigation. The respondent number 7 is running the mixed hard tar plant, my lord, without following the due procedure of law. There is already order from the pollution control board, my lord, to stop and shift the premises. Even though they are not shifting, my lord, it is a case of nuisance, health hazard to the residents of the locality and farmers, my lord, and they were unable to carry on the agriculture operations. Crops are being damaged and there is a school nearby, my lord. The students are also affected by the mixed hard tar plant, my lord. There is already an order from the pollution control board, which is at annexure, yes, my lord. Page 94.
So it has to be private litigation, no public interest.
No, my lord, the farmers are affected, my lord.
Lord, the
Kindly see.
action has to be, further action hasn't been initiated by the pollution control board, my lord. The photographs are a bit disturbing.
My lord, the permission is only granted for stone polishing, my lord, which can be seen in annexure B. And the panchayat has issued an endorsement stating that they have not given any permission to run the tar plant, my lord. And the merger is also drawn in front of all the villagers. Merger report is at annexure F, my lord. Crops are being damaged and there is a poultry farm, my lord. Lot of chicks, birds has been died due to this smoke. School is there, my lord. The school principal headmaster has written a letter which can be seen in annexure H, my lord. Students are affected due to this sound.
Notice was
Sericulture.
issued to you.
Oh, notice was issued by the pollution control board, my lord, to this,
Unit.
yes.
What have you to state?
Please.
It's coming up already. It's coming up for the first time.
Then you take it to logical.
We will.
Where is that?
Annexure S, my lord.
Annexure S 94.
Issued to respondent number 6.
We dispose it.
Yes. You have to take decision on this.
Its notice is, it's coming up for the first time for this court.
That's all right. But you have already initiated the action.
So we'll take it to a logical conclusion.
Take it to logical conclusion. Now already initiation of proceedings happened now. They have to take the proceedings to their logical conclusion.
Even though this there was a direction to stop by the sericulture department also, my lord, they are not stopping, my lord. Sericulture department has also written a letter, my lord. Kindly see annexure J for a moment, my lord.
No, this is coming for the first time. You want to see the controversy, then you file your counter also.
That's a controversy that can be resolved, that's at our end itself.
But you, Mr. Chaudhary, file counter, formal counter, so that it may give a base to the court to properly appreciate the court.
2 weeks later.
Issue notice, dispose upon that day,
Please.
subject to what you say. Heard learned advocate Mr. So and so for the Read petitioner.
2, 3 for AGA.
Returnable on 1st April.
My lord, I take notice for respondents 1, 2, 3.
Yes.
4.
4 is Chaudhary.
Yes.
I would take notice for respondent number 4.
4. 1st April, learned additional government advocate accepts notice on behalf of 1, 2, 3.
Yes, my lord.
Whereas learned advocate, Mr. What is your first name?
Mahesh, it's Mahesh Chaudhary.
Mahesh Chaudhary for the respondent for pollution board accepts notice
To others.
on behalf of the board. Counter affidavit may be filed
Copies may be served with it, sir.
by the respondents before the next date. Learned advocate of the petition shall serve copy of the compilation of the petition to both the learned advocates within 3 days.
Mr. Blazmi.
Number 65. Narayan
In this
Naik.
case, my lord, the petitioner is running a fish cutting unit, my lord, employed about 60 women on a daily wage basis. The consent was issued to the petitioner industry.
You all are keeping Mr. Chaudhary on toes.
Yes, please.
Not
Kindly
permitting him to sit. Yes, what do you want?
Consent was issued to the industry, but I have produced annexure C.
That's I have.
That has been now withdrawn without notice, my lord.
Without notice.
Without notice, my lord. Law mandates, my lord, notice has to be issued.
Petition
Section 20.
may have become infructuous.
Because
Because my lords, subsequent to the withdrawal of the consent order, they have given a letter on 15th of Feb 2024 seeking for modification of a condition in the consent order, or based on which we withdrew it. Now, my lords, on that an order has been passed on 26th of Feb 2024. So, my lords, indirectly they have accepted the withdrawal, and my lords have sought for. May take my lords to the fact. So, what has
But
happened?
may
here is that, my
submission
lords,
may not be correct, my learned will not.
hearing was not given. That, my lords, is a settled fact here. That we are not, I'm not going to argue on that, my lords. But why it was not given, my lords, is on 2 aspects. Number 1,
you only gave the letter.
yes. No, that's the second aspect, my lords. The first aspect is the petitioner's industry was called in question before the NGT, my lords. And my lords, even today, the matter is pending before the NGT, and NGT has issued a series of directions to the Pollution Control Board so as to take action. And in addition to it, my lords, there's even direction to not to operate to them. And my lords, according to the order by the NGT, from 30th of May 2023, the industry is not functioning. That is a recording by NGT itself. That is one aspect. The second aspect is that, my lords, we had given a consent saying that within 4 months you have to get CRZ clearance, coastal regulatory zone clearance, my lords, which was not taken, which was not obtained by the petitioner. My lords, that very condition, they've given a letter. If my lords may have my counter at page number 62, annexure R10.
Lord, may I make submission?
We'll hear it. Yes, 62.
Page 62, annexure R10.
62 is some
That's on my counter.
annexure E. No, annexure. Your counter.
Yes, sir, it's my counter.
Annexure R10.
Yes, sir. Let's may see the date.
By petitioner.
Yes, sir. And my lords, the only grievance, my lords may see the subject, my lords, as per the provisions of so and so, to revoke additional condition number 1 stipulated in consent for operation dated 18/4/2023 issued. And that condition, my lords will find it next page in the middle quadrant. The applicant
Shall obtain.
Shall obtain coastal regulation zone clearance from Department of Ecology and Environment within 4 months, failing which this consent issued will be deemed to be withdrawn. This is a representation which they have given. We have considered that. And at page number 70, annexure R12, they have rejected it. By implication, they have accepted whatever we have done to the petitioner industry.
You declined to delete that condition.
Please, Madams. We refuse to decline it, Madams, for the reason that Madams, the matter is pending before NGT. Even
The
today,
identical subject.
identical subject, same petitioner, same unit number. It's pending.
What is the subject matter?
Madams, subject matter is, Madams, the villager, Madams, one of the villager has gone before the NGT, saying that, Madams, number one, the units, there are two units, Madams, one run by the petitioner, the other one in the name of the wife of the petitioner. Saying that, Madams, they have not obtained CRZ clearances, they have got the land converted by providing erroneous documents. And Madams, Pollution Control Board is not doing their job. No, these are the three subject matters before the NGT. That's on 22nd of September 2023, an order came to be passed, giving us a line of directions, Madams. After which, Madams, admittedly, Madams, we also did not follow it. A contempt petition came to be filed before the NGT and it's pending today. As of today, the subject matter, they are also before the NGT. They've participated extensively, Madams, over 2.5 years until the judgment has come out in last year in the month of September. Madams, going by that aspect, Madams, they cannot possibly contest. On the aspect of natural justice is my submission. Because Madams, if you have not heard, there's an organization, the tribunal, which is bigger than us, who monitors us, Madams, have heard them. That's his only grievance, Madams, that we have not heard the petitioner.
Make my submission. All these grounds, my lord, have not been stated in the order. They cannot supplement the reasons, my lord, in the order which is not there, and they cannot make a order which is bad in its inception. And when it reaches to court, my lord,
it's all right, but these are all on record.
No, my lord, I'm on different aspect. Kindly see, Annexer A, Annexer A, order and the impugned order. They cannot harass, my lord, the industrialist like this. No. Kindly see. I will come to it, my lord. Page number 25. Impugned order. Last paragraph.
So you withdrew the consent?
Yes, my lord.
1 second. You withdrew the consent pursuant to your decline of modifying the condition?
No, Madams, it was prior to that.
Prior to that?
Prior to that. And Madams, on the ground that we have given 4 months time for you to go and get.
Consent stands automatically rescinded if he does not obtain the necessary clearance. That is the stipulation. These are all statutory licenses. Contractual. So where a condition is stipulated, if you do not comply with the condition, permit rescinding of the plan. Therefore, this will be superfluous. Subsequently, whatever order of first year challenge, not able to benefit because in effect, license is not condition.
Kindly page 25, my lord. 25.
Yes.
The consent order, withdrawal of the consent order without notice, my lord. Last 3 lines.
Yes.
The then CEO in the zonal office, Mangalore, has issued consent to the industry for fish cutting activity of 750 tons per month, with reference to. The said consent was issued to the industry for its operation with the following specific conditions, among others. Kindly next page. Applicant shall obtain clearance from the Department of Ecology and Environment. Kindly mark the Department of Ecology and Environment within 4 months, failing which the consent will be deemed to be withdrawn. Next paragraph 4, fourth condition. The consent is issued for permanent cutting building, fish cutting building to the extent of 240 square meters and permanent cement sheet roofing on building 2 to an extent of 31 square meters, which is situated in survey number 71 only, for which kindly mark opinion has been given by the Regional Director Environment, CRZ office, stating that this survey number falls beyond CRZ range, wide letter number so and so 5823. According to their own case, I am beyond CRZ zone. There is no violation at all. This condition, Lord, is a redundant condition. Next condition, paragraph unnumbered para 2. What they say is, on verification of the file, it is observed, my lord, got it. Second unnumbered para, same page, page 26.
On verification of
the file, it is observed that consent is issued with the condition that industry should submit CRZ clearance within 4 months period, failing which the consent is deemed to be drawn. Next line kindly important. The consent is issued on 14th August 2023, and it is already 4 months since the consent issue of consent. Industry has failed to submit the CRZ clearance from kindly mark, my lord, Karnataka State Coastal Zone Management Authority. This is not the condition earlier. They want from the Environment Department. Now they say, Lord, Karnataka State Coastal Zoning Management Authority. This is different authority.
Where is the order of, order granting consent?
Kindly see. Page numbers, Annex C, page 30. The consent conditions, my lord, single line, my lord, page 33 consent conditions are. Kindly see, my lord, Annex C, consent period, date of issue was 14/8/2023. Page number 30, my lord, Annex C. 14/8/2023. Validity period 27/2023 to 30th September 2032. Now, my lord, the conditions, my lord, may find at page number 33. Those conditions have read, my lord, page number 26. They have called out here. Single line,
Conditions, sir?
conditions, page 33, additional conditions. Same conditions I have read earlier. That I have to obtain consent, environmental CRZ clearance from the Department of Ecology and Environment. That is different. No, my lord, they say, my lord, I have not obtained clearance from the KCZMA. That is different authority. Saying one thing, asking something, my lord, making something to make. No, my lord, I am admittedly, according to their own records, my lord, I am beyond the CRZ zone. Kindly, I have produced, my lord, a map, page number 40.
1 second. Which law authorizes you to insist upon clearance from that, which you have said?
CRZ clearance.
That's at the outset. May I mention this? It is a typographical mistake, that's in the consent as well as the withdrawal, that it's mentioned as ecology and environment. The authority for that is Karnataka State Zonal Coastal Regulatory Authority itself. Now, that is a mistake. That cannot be taken advantage of by.
Have you stated in your objection statement?
This is not stated, but I have produced the report of the case, the authority itself, to prove that they are actually going beyond their functioning. May I take my lords to the report?
But here, my lord, kindly permit for
Just to clarify.
Please.
That's page 55, annexure R8. That's what is important is that, if I may take my lords to directly to page number 57. What has happened here is the Karnataka State Coastal Zone Management Authority is constituted under the MOEF,
Ministry of?
Environmental Forest. It is an inadvertent mistake that forest and ecology has come. But actual authority is Karnataka State Coastal Zone Management Authority. And at page number 57, a tabular column is put up by the state, which was submitted before the NGT, which even the petitioner is a party to. Let's look at temporary cement sheet roofing, permanent fish cutting, temporary cement sheet roofing to office building. That's what the minimum which has to be. It should be beyond 50 and above meters. Let's look at 19 meters, 24 meters, 63 meters, 66 meters. It is, I ask myself, which part of it can I allow, which part I cannot allow, and that is the reason, we told, please go get a CRZ clearance, because assuming that it's one room, look at the permanent fish cutting building is within the CRZ zone, which is CRZ 3 non-development zone. NDZ stands for non-development zone. Number one, look at the conclusion of it. I may take my lords to paragraph number 58, page number 58, below the table, my lords. According to the coastal regulation zone, my lords had asked me a question, under which regulation or law, my lords? Under the coastal regulation zone notification 2011, property shown in serial number 1 to 4 in the above table to unit 1, fish cutting unit, and it falls within coastal regulation zone. And the property shown in its serial number 5 ETP unit falls within the coastal regulation zone, and the property shown in serial number 6 and 7 belongs to unit 2, a print area of about 97 square meter of powder unit falls within coastal regulation zone, whereas the print area of 976 falls outside. That's what I'm trying to explain by showing this table, and conclusion is that I ask myself, in a room, if one part of it is where the cutting is taking place, the other part of it is where the processing is taking place, it cannot function independently, unless and until the petitioner demonstrates that it can independently function. So this would be a mandatory condition, we are also looking even beyond one level beyond as a board.
How much after that stipulation of condition, how many times you have interacted with each other by letters?
We have inspected up till October.
No, letter correspondence between the petitioner and your board.
Until the
Anyway, they have indicated that stipulation is, it wrongly mentions but X department, in fact, it should be Y department, read that way. No, even his application was on the premise that you needed that permission itself, and he had sought for removal. Even there also you did not say that. Then how to?
To bridge that, my submission would be is the NGT proceedings which the petitioner is a part of. He was a part of the NGT proceedings. That's if I may take the NGT order, he's been.
You stated in your.
Yes, said that.
We have. The fact that I would only make one submission, on the date of filing of this writ petition also, which is, I given to understand it's on 11th of January 2024. NGT proceedings were pending, that is not brought on record even in a single page, not even amendment has been made.
Though he is a party there.
Yes, and in fact, they filed a K-weight in a contempt petition. That order sheet also have enclosed. That's K-weight in a contempt petition, it's like anticipating that yes, I'll be doing something wrong. So I know NGT is going to take action against me. That's person, if he's claiming natural justice on equity principles, that first principle, he needs to come clean before the court.
Lord, may I
and what he's done, he changes the name of the petitioner to Keshav Kundar. In brackets below that, mentions the unit's name, even in this petition. While in the original petition, it is the unit's name and then his name. The significance is only one thing, is that to portray that I do not know anything about NGT.
May I make submission? Page 58, Learned Friend has read. Lord, first of all, Lord, he should be fair for himself. But this kindly see, Lord, page 58. What according to the Coastal Regulation Zone Notification 2011, that has been superseded by another notification that he has not stated so. Very sorry, my lord, council opinion for the board authority cannot make such a submission, my lord, and at the risk of the poor persons, my lord, who are working for daily wages.
Superseded by another notification.
Another notification, kindly see,
there is no such condition.
Condition is there, 50 meter, earlier 100 meters.
I'm talking of 50 meters only.
Kindly, that notification is superseded now.
But it is within the zone only.
No, there is not, I will show, my lord. Their own affidavit, kindly see. I'm sorry, their own affidavit, kindly page number, my lord, 67. 67 of their own counter. Their own counter, they filed a counter before the NGT, page 67. Kindly see, my lord. Vijaya Hegde, so and so and so and so. Page 67 of their counter.
67.
Yes.
Yes.
Vijaya Hegde, etc., senior environmental officer, etc. She has filed affidavit before the NGT. Kindly see next page, recommendations of the environmental officer. They have quoted. Previous consent was expired on 30th September 2022. As per CH-1 notification 2019, the distance criteria revised from 100 meters to
Where you are reading?
page 68, my lord.
68, yes.
68 of their counter.
Yes, counter.
Bottom recommendations of the environmental officer.
You got it.
Previous consent was expired on 30th September 2022. As per the CRZ notification 2019, the distance criteria revised from 100 meters to 50 meters from high tide line. The coastal zone management plan is approved on 2/9/2022 by central government, and same was informed by the regional director environment would be wide letter dated 14/10/2022. As per the CRZ authority and distance criteria as mentioned about table, serial number 3 and 4, for the shed located in survey number 71, kindly mark measuring 240 where I am running the industry.
Out of the CRZ area.
Yes. It is their own, no, I have produced not a map also, kindly map, CRZ, see their own map. Central government, kindly page number 40 of my petition. But having said so, my lord, whether it is open for them to say that I am violating the CRZ notification. It is their own document. They filed in the before the NGT, saying that I am beyond the 50 meters, where my lord fish cutting activities are permissible. Now kindly see page number 40 of my petition. I have produced the map itself, color map.
That's if the authority is saying that they are within CRZ zone. In fact, that's
It is not my document, it's their document.
Right.
Page number 40 of my petition, kindly for a while. My lord.
Are situated outside CRZ area.
That's, I'm also making that statement, that's that a part of it, according to what even the CRZ is coming up, part of it is that is exact difficulty. Which part are they going to use? Once they enter, will turn to page 57, not my record.
No,
not
he's
this
your
record.
officer only. Mr. Hegde, environmental officer, is your officer.
Yes, yes.
He says, kindly read that, kindly come to page 69 now. As the permanent fish cutting area are situated outside the CRZ area.
This is not my statement, I have extracted an inspection report. This is not.
Did you dispute that? Did you dispute this?
Even now, we are saying that a part of it,
Where is that?
that's at page number 57. Not my report, not their report. It is a authority which is given page 58. 57, 58.
That is on the premise that it was earlier 100 feet or 100 meters?
100 meters.
100 meters. Now it has been reduced to 50 meters.
That's may see 57, column number 1, 2. Fifth column, that's 19 meters. 24 meters. It's on my, we have not generated this report, Madam. It is a report by the authority.
Sorry for intervention, my lord. Page 40 may kindly for a while. Lord, may page 40 for a while.
Now, you are saying part of that is within the area, even in the superseding notification.
Yes.
He says it is not within that. Now, the best way is together you say whomsoever you want to, we will appoint somebody, let them go and measure that area, bring a report. We will have the factuals.
Request, that's may direct the Karnataka State Coastal Zone Management Authority only to do the needful.
But may one submission, no, one submission, it will clarify, it's map I have produced, page 41. Page 41, kindly see my petition. Page 41, Lord, it is a map prepared by the Coastal Zone Management Authority. Page 41. Color map I have produced, kindly see, Lord, CZMP 2018. There, Lord, letter KL line.
Which is the agency?
That's it is Karnataka State Coastal Zone Management Authority.
In this map, what you want to show?
Kindly see, Lord, kindly see. The KL line, kindly mark, KL line is the 50-meter boundary. Thereafter, Lord, KLHGEF, that is 240 meter. Then, Lord, EGF, J, this is 318 meters. It is their own map, Lord.
We will draw one report from
another aspect, kindly, another aspect. And another, kindly see me, Lord. Page number 62. May one submission, I'll clarify. Two aspects, my Lord, kindly appreciate. Page number 62 of their counter, wherein, my Lord, a letter from the petitioner has been produced. Page number 62. Next, my Lord, page number 64, paragraph 4. Kindly see, my Lord, two things I read. Paragraph 4 and 5. Sir, on 5/4/23, the Regional Director, Environment, Udupi District addressed a communication to the Principal Secretary, Environment and Ecology, Department of Forest, Ecology and Environment, Bangalore, enclosing a colored map showing the location of two buildings measuring 240 and 380 square meters that falls outside 50 meters of no development zone beyond the coastal zone, regulation zone. Copy of the communication and the color map is enclosed. Next important, kindly listen, sir. Recently on 5/1/2014 to 2024, you have issued a consent
To
for
BMT fish.
for operation of one BMT fishing peeling industry situated hardly within 20 meters. That is on 5/5/1, whereas my withdrawal is on 3/1. Kindly then from river Sita, HTL high tide loan and within 150 meters from the sea high tide line, which is in utter violation of CRZ 2019 notification, and you have not stipulated the condition to obtain CRZ clearance. Kindly note that your said action is arbitrary, etc. But they are permitting whatever, whoever they want, and they are troubling us, my Lord. In a similar two matters, my Lord was pleased to grant stay in other two matters, my Lord. I am having interim orders of
See the
Kindly see,
paragraph
Lord.
number 4, it says two buildings. There are 4 buildings in total.
Anyway,
There's a report.
now distance cannot be changed by
Yes,
argument. It can be
There are
measured,
two
fortunately.
two interim orders I am passing, Lord, wherein a similar issue was involved. My Lord was pleased to stay the Lord interim orders. Interim order. Kindly see, Lord, I pass it on. Lord.
We are not passing any order.
Lord, kindly
We are
see, why, my
passing
Lord?
only on
There, my
one
Lord,
order,
right to-
that let it be measured. Short term, within short period, we will have that report from the concerned
Lord, kindly
person.
see, Lord,
You also go there.
Lord, kindly one aspect.
You
My
just have
difficulty,
the
Lord,
vision of sea.
my difficulty.
That will increase your horizon also.
Lord, all other similar industries are operating, Lord, and I am the only person singled out. Similar orders may be passed, Lord. No harm will be there, Lord. There are, Lord, 20 meters, 50 meters inside, Lord, they are operating. Whereas, Lord, I am, Lord, denied, Lord, whether the same benefit, Lord, I am see the same order. My Lord was pleased to pass orders. Two industries, Lord, where also CRZ clearance was involved.
That was a different issue altogether.
Same, he has
altogether.
No, Lord, he cannot, he himself has appeared in this matter.
Altogether. It's a different.
Kindly see, Lord.
How long your industrial activity has been stopped now?
3 months, my Lord, 60 women, my Lord.
Next week we will get the report.
I have
We'll
no
get the
difficulty,
report
my Lord.
within 7-8
Lord,
days.
kindly, what, my Lord, may.
Once you have kept.
No,
quiet and
my Lord,
nothing
no,
has happened.
kindly, why, my Lord, the fish season will be come to an end, my Lord.
Within
Fish season, May in the Suragate, fish season stop, so much amount I have invested, my Lord, for treatment. There is no violation of aspect. There is no complaint against me that I am polluting. I have, my Lord, established ETP. Everything is in order. Only thing, my Lord, is, Lord, I have, we are, the CRZ clearance have not obtained. Similar issue involved in two cases, my Lord, where my Lord was pleased to pass orders. My Lord was party in this case.
The Karnataka State Coastal Management should be implicated in and directed them to file an order.
One day we will get the report.
Please.
Two things. One is distance. Another, whether you have permitted others to operate within that area. If that report goes against you, then yes, heavy cost we may, because you cannot discriminate depending upon greasy things.
I am filing memo, my Lord, wherein, Lord, showing the consent was given to other industry and map also.
That's Karnataka State.
Having heard learned advocate Mr. So-and-so for the petitioner and learned advocate.
Lord, I am producing two memos.
Mahesh Chaudhary for the Pollution Control Board for some time, and having considered the controversy and the issues involved, the court finds it appropriate to require the petitioner to implead Karnataka State Zonal Management Authority.
Coastal Zone Management Authority.
Karnataka State Coastal Zone Management Authority through its competent officer as party respond number 4. Also, the amendment in the course title shall be carried out forthwith.
Who appears for the authority? You appear for the authority. The Karnataka government.
Independent authority.
Independent entity.
Yeah.
So we'll
That's-
notice.
That's we'll find out whether and we'll inform them.
No, I will take notice to the personally, my lord.
So notice
Personally.
returnable on today's 15th,
15.
15th, and services permit.
Are you sure?
Lord, meanwhile, my lord, they may be, I will serve, my lord. They may be directed to inspect, my lord, to tomorrow day.
Service by hand delivery is permitted.
Please.
You amend the petition.
I will amend now. Lord, the two aspects, my lord. One is, my lord, the major.
Let us see.
On 15th will.
Lord, my
Hear
lord.
you. There
Why-
is
why-
something in which you are saying.
Lord, why I am saying, my lord,
Don't exhaust that ground.
Lord, may two mans, kindly, see, Lord, I have given a representation to at least to withdraw the condition that they have rejected, saying that NGT matter is pending. My lord, admittedly, even according to their own records, I am beyond 50 meters. They are not doing it.
It amendment.
Rightly or wrongly, we are ignoring that NGT aspect.
Yes, sir.
You have not uttered one sentence. about
Accepting
I have
your
said so, my lord, regarding main petition, I have said so, my lord.
So on that day, you serve them, then we'll pass the necessary direction.
Please, oblige.
Distance. Yes, right now we can. In that we have, because it's not passing. We can direct them to go to the spot. So that again time can. be
So
saved.
the notice to the newly added respondent shall be returnable on 21st of March. In view of what transpired in course of the hearing, respondent number 4 is directed to undertake the spot inspection of the unit of the petitioner
As well as, my lord, the
and
BMT fish
and
feeding.
to submit report to the court as to the distance it bears from the boundary of coastal,
HTL, my lord, high tide
In
line,
terms of
what is called?
HTL.
HT, high tide line.
From the boundary of high-tech line with reference to the coastal zone
regulation of 20.
regulations.
And that the other industry is permitted to operate within the zone. That's one of the. It may be wrong, that will not say it.
Lord, that's a discrimination I have alleged, my lord. BMT fish feeding industry, hardly, my lord, 20 meters it is situated, but they are permitting.
Chaudhary, if other industries are functioning,
Well, I'm
That-
Yazad's hand.
that may not give right to relief, but that will really entail cost on you.
In fact, Minutes, I may mention that Minutes NGT has called for the report or the say by the environmental officer who has given them the consent. But that is also pending before NGT. That's behind Yazad's hand.
NGT has called for report regarding?
Called report with regard to Minutes, whoever has given them the consent
Within the area.
in the area as to why you have given them the consent in spite of our orders.
We are not interjecting anything.
No, I'm just placing before my words.
The fact that other industries are operating within the area without this clearance. Therefore, they have issued notice.
Please.
Yes.
Please.
You will take hand service?
And
I will amend now, my lord.
And placing reliance on interim orders passed by this honorable court in identical matters that may be taken up for a minute.
Next week.
I mean, 71.
number
my lord,
74.
is hearing before charge. The urgency is not for 20 years. I'm without job, my lord. They are not implementing the order. Because for hearing before charge, lordships have heard it substantially. my lord. Heard, may have it at the earliest convenience. At KPSC, they are not appointing me, my lord. Since 20 years, I'm struggling.
Nobody has been appointed pursuant to the
No, they are appointed, my lord, and against my appointment, where, my lord, ineligible candidates have been appointed appointed as latest as today. I am suffering, my lord, for 20 years. And it is, my lord, hearing before charge, already, my lord, the any shortest date
After 10 days.
the
Serial
early
number
part of the list, my
74,
lord,
my
not in the
lord.
end.
Number 67.
Pardon? All, I accept those days.
First week of April.
Second April.
Serial number 74.
Earlier date.
Can I make a request, my lord, matter may be adjourned after 22nd?
If any date of choice you want,
In fact, I have informed, my lord.
any date after 10 days, but any date of choice you can give.
At 66, can I request tomorrow at least, my lord?
Tomorrow?
Tomorrow, my lord, it's interim, placing reliance on some interim orders.
Tomorrow will not appear on it.
Fresh matter, my lord. OCA students not being allowed to write the examination or to participate in the counseling. Therefore, it can be taken up on Monday or Tuesday.
When the examination, counseling,
First week of
April, then 22nd,
My lord,
March.
Serial number 75, my lords, construction is stopped from the last 14 years. My lords, the previous bench had heard the matter in part, but it could not be taken up afterwards. Some urgency in the matter, my lords. The construction is stopped, the road, they have blocked the road.
Arun,
Please,
which
my lord.
matter?
Serial number 75, my lords. 70.
Final hearing.
Final hearing, it was admitted on a sole ground. Corporation made a mention that some directions are issued to the corporation, but my matter is suffering 75.1. 75.1 is the main matter that is suffering, and 15 years construction is stopped, my lords.
We'll post it as early as possible.
So,
After
lords,
week or 10 days also.
at
After 10.
2:30, my lords, any day, otherwise it will.
Yes, date is being given.
Please, my lord.
With permission, my lord. Serial number 70, appointment to the district consumer forum, my lords. That identical question, my lord. Now the Supreme Court has decided that the appointments are illegal, rules are illegal. That's under challenge before this honorable court, my lord. That's a grave urgency in the matter, my lord.
After, no, it doesn't that urgent. It is not that urgent.
Because all the appointments are stuck down, my lords. The illegal appointments are continuing.
After 15 days.
Please.